Hello, everyone. Welcome. Sorry, we are a few minutes late. My name is Jiann, and I am currently the Business and Fundraising Editor of the Santa Clara Journal of International Law. We want to welcome everyone to our annual symposium with the topic of international arbitration, the doctrinal foundation, and practical applications in 2021. We have an incredible lineup of speakers today over our 3 panels, concluding with our keynote speaker address from the Vice President of the ICC Court of Arbitration, Ms. Chiann. All of our panels today will be moderated by great professors from the Santa Clara University School of Law, and I will now turn it over to Melina.
Thank you so much, Kwa. Hi, everyone. My name is Melina Moss-Vasquez, and I'm one of the managing editors of the Santa Clara University Journal of International Law. We want to thank you all for joining us today and take a moment to recognize this unique nature of our virtual symposium. We are honored to be accommodating a significant turnout of attendees, and we would just like to recognize all those who are joining us from all around the world today, from quite a few different countries, such as Vietnam, Korea, Nigeria, Austria, and Japan, just to name a few. You may already be familiar with some of Zoom's webinar functions, but we would like to remind everyone of some of these features and general house rules. Please note that all attendees will not have access to video and microphone capabilities. However, we want to encourage you to send any questions you may have for our panelists in the Q&A function, which you can find located at the bottom of this window. Please know that we are recording this event, and if you run into any technical issues at all, you may contact Kwa directly via his email address noted in your registration email. I will now turn it over to Jackie Silva.
Hi, everyone. My name is Jackie Silva, and I'm a managing editor of the Santa Clara University Journal of International Law. We're really excited to have you with us today and are very pleased to be offering MCLE credits to all of the California attorneys in attendance. I will take just a brief moment to explain this process, which will be happening behind the scenes remotely. And we'll note, if you are interested in receiving MCLE credit and did not already indicate this upon registration, please reach out via email, which we will provide in the chat, and we will be sure to add your information to our records. Given this is going to be handled remotely, at the start of every panel, I will be emailing an attendance form to all those who have registered for MCLE credits. Please provide your electronic signature on the form, including your California bar number, and return to us for our records. At the end of each panel, you can expect to receive the MCLE evaluation form and certification form to all those whose signatures we received. Please fill out the forms and return them to the email address which you will be receiving them from, and we will keep them for our records to note your MCLE credit. We will be putting the email addresses in the chat box for you to be able to access. We're so excited to begin this event. I'm going to hand the back over to Kwa so that he can get us started with our first introduction.
We would like to introduce Professor Philip Jimenez, who is currently the professor at Santa Clara University School of Law for so many years, and he will also be the moderator for this event. Professor Jimenez, I'm turning it over to you.
Thank you, Kwa. Nice job. First of all, what I'd like to do is to recognize and offer this measure of gratitude to the board of the International Law Journal, Michael Romero, Melina Moss-Vasquez, Kwa Nguyen, and Jacqueline Silva for the dedication, innovation, and vision in putting this thing together. Nice job. I was very, very happy and impressed to see the amount of really productive collaboration on your parts. Very nice job. Thank you so much. Santa Clara Law School has had a focus on international law for many decades. Nationally and internationally recognized for the excellence of our programs. And certainly this International Law Journal adds a great deal of luster to our reputation, notably in its publication of fine work, but also in the presentation of these excellent symposia. Once again, thanks very much. Certainly, much credit for our survival in the face of this pandemic and our continuing focus on international law must be given to our Dean, Anna Hahn, who has defined the term grace under fire. Really a stellar job. Recognition and thanks should also be given to my colleagues, Professor Donald Polden, former Dean and Director of the Center on Global Law and Policy, Professor Tse-Ming Yang, the current director, and Professors David Sloss and Gary Benton, whom you will meet a little bit later on. All wonderful people, wonderful examples for the young lawyers in which we seek to instill a passion for this field. So let's get on to the question of today's program. As the world awakens to the reality of frustrated goals and expectations, and the daunting challenges we face in addressing the havoc that was caused by this pandemic, lawyers need increasingly efficiency, speed, and certainty in resolving disputes. Increasingly, the choice is arbitration and its advantages. Number one, speed. Two, informality. 3, confidentiality. 4, it's inexpensive, at least comparatively so. Arbitral awards, unlike other judgments, are recognizable and enforceable by treaty. And of course, parties may choose a neutral ground. Many choices are open to parties, and these will be set forth as our first panelist, Mr. Richard Eastman, longtime friend and recognized expert, will seek to address that. In many ways, Mr. Eastman requires no introduction, as he's well known nationally as well as internationally, and his services are widely and much sought after. So, Mr. Eastman, I turn the floor over to you. Thank you so much. We look forward to hearing you.
Thank you very much, Professor Jimenez. I think I need somebody to let me be shown qua. Okay, there I am. You can see from the background that I live in a very cold place. I have a house in the mountains of Japan, Nikko, and I'm offering that as my simulated background for this presentation. I want to join Professor Jimenez in my thanks to the board of the Santa Clara University Journal of International Law for organizing this symposium, and also for giving me the honor of being the kickoff panelist. So let's get started. I cannot screen share while other write. Can somebody let me screen share? Thank you. Right, so what I'm going to talk about today, and I apologize that it is a relatively basic presentation. We'll gallop through a number of topics, starting with what is arbitration, history of arbitration, and then focusing on international commercial arbitration. So let's get started. What is arbitration? Arbitration has been used loosely for various forms of dispute resolution going back centuries. But for our purposes today, arbitration means a legally binding agreement exists between parties to resolve disputes already in existence or future disputes. If it's a dispute already in existence, we say that the parties enter a submission agreement. If they are agreeing to resolve future disputes, that's usually a arbitration clause in a contract for another purpose, buying and selling goods or construction or many other types of contracts. When a dispute arises, one or more arbitrators are appointed. They consider the parties' submissions. There may be an evidentiary hearing, or many proceedings are decided on documents only. The arbitrators enter an award, deciding the issues between the parties, and that award is legally binding and may be enforced under arbitration laws in the courts. Arbitration started a long time ago, thousands of years ago, although distinctions between arbitration, litigation, and mediation were often not that clear. Arbitration, as I described it just now, gradually took its modern shape, starting as long ago as the 18th century. And In the early 20th century, it had more or less approached the description I had in a prior slide. For instance, New York State enacted the first arbitration law in the US in 1920, and the Federal Arbitration Act followed 5 years later. So that's almost 100 years ago. In that time, arbitration has become very prevalent in commercial agreements, both domestic and international. And in the US and some other countries, it's used a lot in employment agreements and consumer agreements as well. So international commercial arbitration. You may think you know when you have spotted an international commercial arbitration, but there are legal definitions which need to be kept in mind. We'll be talking a lot about the New York Convention. If you want to enforce your arbitration award in another country, you have to be sure that it qualifies as such under the definition of the convention, which we'll look at in a minute. Also, places like California have different laws governing domestic arbitrations as opposed to international arbitrations. So you better know whether you have an arbitration which is international by the definition in the law of the place where the arbitration is being conducted. For instance, in California, if you have a domestic arbitration, you better have legal fees. Awards of legal fees need to be specified in the arbitration clause. However, under California international arbitration law, which is based on the model law, Untitled model law, arbitration counsel fees can be recovered pursuant to the law itself. International arbitrations are defined differently in the New York Convention as contrasted with Untitled model law. The convention is on its face not limited to commercial arbitrations. It has no definition of commercial. Model law is limited to commercial arbitrations, but likewise has no definition. There is a Untitled footnote urging inclusive interpretation of the meaning of commercial. These are the actual words of the New York Convention on your screen. Defining what arbitral awards will be enforceable internationally. The first one is a very sensible one. If the arbitration award is from another country, it's under the convention. The second sentence is more abstruse. It applies to arbitration awards not considered as domestic awards in the state where their recognition or enforcement is sought. That sounds almost like a koan, but there's a case law on what that means, and it's one of the interesting wrinkles in the convention. Under the model law, there's A, B, and C categories of international arbitrations, and I invite you to study what they are there. International arbitration is quite active. On your screen now is a selection of major arbitration institutions and their reported new cases in the years 2019 and in some cases 2020. CTEC is the major Chinese center for arbitration, and you can see that it's very, very active. The ICC, and we had the honor of a keynote speaker from the ICC. That's the International Chamber of Commerce in Paris, Court of International Arbitration. ICDR is the American Arbitration Association International Wing. You can see in 2019, they slightly exceeded the ICC in a number of cases. The other lists in the other institutions listed here are Hong Kong, Korea, and Singapore. And you can see that Singapore is up and coming. It had over 1,000 cases through October last year. Ad hoc, we'll talk about ad hoc in a minute. We don't have statistics for ad hoc arbitrations because they don't have an institution that could report them to us. The New York Convention is a key element. Professor Jimenez made mention of it. It is the basis for the success and popularity of international commercial arbitration because it facilitates enforcement of arbitration awards in other countries and is much preferable to litigation where judgments are not that easily enforceable as compared with arbitration awards. Under the convention, the member states promised to give effect to private agreements to arbitrate, and they promised to recognize and enforce arbitration awards made in other member states. This is not, the arbitration awards have to be kosher. Article 5 of the convention lists a number of instances in which recognition and enforcement may be refused, where the parties were not capable of contracting, where the party was not given notice or allowed to participate, etc. In addition, more problematic, if you will, reasons not to enforce it is if the award is contrary to the public policy of the country where enforcement is sought. I said that member countries are required to enforce awards from member countries. Actually, on the face of the convention, it says that they must enforce all foreign awards. But in joining the convention, a country can opt out of the obligation to enforce awards against non-member, to enforce awards from non-member countries, and virtually all members of the convention, of which there are 124 countries, almost all countries have joined the convention. Almost all of those countries have opted out of the obligation to enforce awards against non-member, from non-member countries. It's also interesting that many countries have opted to limit their obligation to commercial contracts only, so that although the New York Convention on its face does not govern only commercial contracts, in practice that is mostly what it is employed to enforce. Overall compliance with the New York Convention by member states has been excellent. China, for a while, local courts were reluctant to enforce awards from overseas, but now in China, if a local court elects not to enforce an award, it must refer the matter to the People's Supreme Court in Beijing. People's Republic of China has a strong policy of enforcing awards. There's a lot to the convention. It deserves a symposium of its own. Moving on, the other really important thing to know, to understand about arbitration is the role of arbitral institutions. I gave you a list in my statistical slide. Here you can see at the bottom of this slide a list of the same major countries, same major institutions. What are the important roles? If you have put in your clause that you will arbitrate under a particular arbitral institution, that institution will give a preliminary vetting to whether or not there is an arbitration agreement. If you haven't specified how to appoint arbitrators, it will do that for you. It has well thought out rules which will apply to the procedures. Very important is custody and control over funds paid by the parties to cover the cost of the arbitration, rules controlling compensation of arbitrators, and quality control over arbitrators, including review of the draft award. In varying degrees, most institutions will vet the draft award. Editing it, they don't tell the arbitrator what to decide, but they try to make sure the arbitrators stated in an acceptable and clear way. In contrast to institutional arbitration, we have ad hoc arbitration, which essentially means arbitrations that aren't administered by an institution. Traditionally in England, ad hoc arbitration is common. The lawyers and parties understand it, the courts understand it. Likewise, maritime arbitration flourishes, especially in London. For the unwary or inexperienced, there are pitfalls to ad hoc arbitration. It's key to cover these pitfalls in your arbitration agreement. What am I talking about? Well, in an ad hoc arbitration, for instance, if you haven't specified it in your clause, you're not subject to any body of rules. Untitled, which promulgated the New York Convention also and the model law, also had promulgated rules designed for ad hoc arbitrations, which could be incorporated. The parties may have to ask a court to appoint the arbitral tribunal if they can't agree and if the clause doesn't provide a procedure. Under the UNCITRAL rules, for example, you have to go to the International Court of Arbitration in The Hague, which doesn't seem very practical for most purposes. So it's good to cover that. Funds to be paid to cover expenses, including arbitrator compensation, must be paid directly to the arbitral tribunal. So it's in a related aspect, it's imperative to have agreed in advance with the arbitral tribunal about their compensation. And this is a sensitive point in ad hoc arbitration for the unwary. Today, almost every country has arbitration laws. I've provided a table of sources and resources in the program materials where you will find citations to most of the laws of the world and books and articles discussing them. And we're hopeful that my colleague, lawyer Takatori, will be addressing modern arbitration law after I get done. The cutting edge standard for arbitration laws is the UNCITRAL model law. Its basic principles are party autonomy. Arbitration procedures are for the parties to set. It limits and clearly defines the roles that courts can take. Courts in the past have been often negative about arbitration. And in the modern world, it's good to have laws that tell them what they can and cannot do to interfere with the process. Competence is a very interesting aspect. The arbitral tribunal has the power to decide its own jurisdiction. That's not final. Parties can appeal to the courts if they think that the jurisdiction is not there. In most countries of the world, although interestingly, that point is not entirely clear. In America, the laws do not deal with competence, or the FAA does not. But if it's put into the agreement, to arbitrate, that the arbitral tribunal has power to decide its own jurisdiction. And most rules, American Arbitration Association, ICBR, do have such a clause, so it is in your agreement if you appeal to those rules. It's not entirely clear that the arbitrator's decision is not final. The model law has been quite successful too. It's been adopted in 117 jurisdictions. Not all arbitration laws follow it. England consciously designed a different law with interesting differences. It preserves more of a rule for the courts. They can be appealed to in the process of the arbitration on points of law, and in limited circumstances, you can appeal decisions of the arbitrator to the courts in England. This is not true most anywhere else. France is interesting. It too has quite a different format and substance, including the very interesting provision that the French courts have jurisdiction of any arbitration being held anywhere if, quote, one of the parties is exposed to a denial of justice. I think this is primarily designed for the protection of French parties. The United States FAA, we said it was adopted in 1925. It's quite short, much simpler than the model law or most other modern arbitration laws. US states have their own arbitration laws, which are preempted by the FAA, but only where they conflict with it, which creates an interesting source of jurisprudence too. So that's my gallop through my subject. Please look at my table of sources, and I hope that there will be questions that I can answer for you as we go forward. Thank you.
So thank you very much, Mr. Eastman. Very, very good. And like you, I look forward to having some questions that we can discuss at the end at the termination of the panel. So it appears that our second speaker, Mr. Takatori, is currently unavailable, but we expect that he'll join us fairly soon. So I think we'll keep this wonderful panel going by introducing Dr. Gabriel Lentner. Once again, an internationally recognized person in the field, present on another extremely important and timely topic, investor-state arbitration. As you can see from his bio, his research and teaching focuses on this subject. He lectures at Danube University in Austria and is associated with well-known institutions in the United States as well, such as Harvard and Stanford. So, if you would, Dr. Lentner, we'd love to hear from you.
Thank you very much, Professor Jimenez. It's a pleasure to be here. Thanks also to the organizers, the board of the International Law Journal. I was lucky enough some years ago, together with Professor Fina, to write an article for the journal, and we looked at the competence of the European Union in the area of international investment law. So that was my first contact with the journal, and it was excellent editing. I know that, I guess that was not your year. I think it was published in 2015 or 14. So that was probably not you, but I know that there is a great tradition of great editing and a very interesting journal. You have great authors in the pages, and it's cited very well and taken seriously. So thanks for having me. Thanks also to my esteemed colleague, Mr. Eastman, who gave you already a great introduction into arbitration, into commercial arbitration. And I would like now to spend the next 20 minutes or so to introduce you to another type of arbitration, that's called international investment arbitration. And you'll see in a minute where these two areas of law are distinguished, and also where there are certain commonalities, especially regarding procedure and some of the elements that they have in common. And also you might know that they are sometimes, depending on the country where you're from. In the US, I remember while researching that, so that was before I was engaged in that field, but in the 90s, when the NAFTA agreement was negotiated and concluded, there was later became very famous, a famous New York Times article that called this investment arbitration system that was part of the NAFTA agreement as secret tribunals of businessmen, business lawyers who decide on the fate of sovereign countries. And so I will also like to use the time I have to shed a light on certain aspects of international investment arbitration, investor-state dispute settlement, as it's also called, where some of the critique might be something worthy to discuss further and to be addressed, and also where there are certain myths and arguments that are not really in line with what is going on in this, I think, very interesting field of international investment protection and investment arbitration. So what I want to do today in the next 20 minutes, I'll give you a short history of the investment arbitration boom. I think it's interesting to note some of the developments here. So to understand the fairly recent boom in investment arbitration, we'll look at that. And then, of course, I'll go through the basics of investor-state dispute settlement. That is the mechanism for foreign investors to initiate proceedings against foreign sovereign states. And the mechanism that does that is very much similar to arbitration as it was discussed by Mr. Eastman previously, a system of arbitration with the procedure of arbitrators, and we also have institutions and so on. So you'll see some similarities there. I'll talk a little bit about typical disputes that are arising and the standards of protection. So this is very unique in that sense, because if you think about commercial arbitration, one of the advantages of international commercial arbitration is, of course, that you're very flexible also with regards to the applicable law, so that even the law of the seat of the arbitration you can choose because of the seat of the arbitration, and of course the applicable law to the contract and so on. This is a very particular field because we are here dealing with international law and treaties between states that have inserted certain standards of protection for investors, on the basis of which foreign investors can then lodge a claim. I'll talk a little bit about procedure, and specifically then about annulment and enforcement. Also here, as Mr. Eastman noted, one of the main treaties that are important is the New York Convention. For investment arbitration, it's also important. Most relevant is, however, the so-called ICSID Convention, also called Washington Convention, that also ensures worldwide in recognition and enforcement of these awards that are rendered against states, if they're rendered against states. And I want to close with some thoughts looking into the future a little bit. There is an ongoing debate within Untitled, which the secretariat is based in Vienna, Austria. So I'm very close to that, and about reform, critique, and the status quo of the field. All right, so the investment arbitration boom actually didn't start until around the 90s, But there have been since the end of the Second World War in the 50s, 60s, a starting of the conclusion of so-called bilateral investment treaties, also called BITs or BITs. So bit by bit, if you allow the pun, more and more treaties were signed between states in order to induce foreign direct investment in of states and within states. Traditionally, or sometimes these were concluded also between former colonial powers and colonies in order to ensure level of protection for these foreign direct investments that are made in these countries. So we're here now in the world of international law, states agreeing to ensure certain standards for protection of foreign investors. And these have been really proliferated around the world. So because they are bilateral treaties, there are now close to 3,000 of those treaties between states that have very similar protection standards. So that's why the system is, even though there are 3,000 different treaties, so imagine 3,000 different business contracts, you know, they would be very, very diverse. But here in with regard to the protection of investors, they're actually quite similar. Of course, you have to look at the specific treaty in the instance, but the general protection standards are very, very similar. But not only these treaties of between states, the most prolific treaty negotiator, I think, you know, classic capital exporting country, UK, Germany, also the United States, and also now up and coming, of course, also China, who signed a lot of these treaties. And beside these agreements, you also have investment agreements, part of trade agreements, free trade agreements, such as NAFTA. That's the famous Chapter 11 of NAFTA, which is now kind of remodeled the USMCA, if you follow that, which actually, so NAFTA included these infamous, as some might call it, because of that New York Times article of the secret tribunals, and we'll talk about more whether that's actually true. Are they that secret? Of NAFTA. In the new USMCA, there is actually more limited ISDS. So this was a political issue. We had that also in Europe, a kind of backlash against these treaties, and we'll look at some of the arguments for or against this in a minute. There are other investment chapters in free trade agreements, multilateral treaties. The most important one in the European context, which involves also really high stake treaties, is the so-called Energy Charter Treaty. So the largest award ever damages award ever being issued was against Russia, which is the so-called UCOS arbitration, which awarded $50 billion US in damages. So this is really high stakes cases. Recently in the news was an agreement, a settlement between Vattenfall, the nuclear energy company, with Germany, where I think the settlement was, I think it was last week, was around 2 billion, but the case was ongoing for a couple of years. So that's been settled now, and this was also being arbitrated under the Energy Charter Treaty. So some of these treaties are more used than others. And then since the mid 1990s, actually from that time on, also I told you the ICSID convention, that's important also for enforcement, but also it provides arbitration institution in Washington, DC, which was entering into force in 1966, but then the following decades there weren't really any cases, very few cases, but then it picked up more and more, and led then to really a dramatic increase from the 1990s on through the 2000s. There are the additional facilities. So if you're not a member of ICSID and other circumstances, Untitled and other arbitration institutions, as we heard already Mr. Eastman talking about these institutions that also help with commercial arbitration. They are also possible institutions where investment claims are administered, and some of them even provide for specific rules for dealing with cases involving sovereign states. So the rationale again behind that being that, well, private investment into countries is an important factor for economic development. So it ensures the flow of foreign direct investment into a country. That's usually the rationale. On the other hand, critics pointed out that the connection and the link between high investment protection and foreign direct investment has not been fully and conclusively been proven empirically. So, obviously economic development and so on involves more than just having protection standards. So this issue is a bit tricky. What I'd like to do here, there's a lot of information out there. I'd like to, give you the outline, describe the area of law here, and also point a little bit to the ongoing discussion and the critique that is available, so that you understand what arguments are made. Let's look at some graphs and statistics. So, we saw the numbers previously of the high number of cases in the various institutions from Mr. Eastman. Of course, investment arbitration, there are larger cases generally. And we have now, I think the stats are from July 2020, around 1,000 cases. And you see here how a majority of cases has been decided, or almost a majority, like a third, decided in favor of the state, the other third decided in favor of the investor, and then some being settled. Of course, that's also a factor that's been has been discussed, and critics pointing out that it's too investor friendly. But when you look at the stats, you see, well, okay, there are also cases that have been decided in favor of the state. On the other hand, you can say, well, but the settlement ratio, if you look at the settlement of Vattenfalls, which the claim was basically because Germany decided after the Fukushima disaster of the nuclear plant there, Germany decided to phase out nuclear energy. And so, of course, that incurred losses for the Vattenfalls, the nuclear power plant company, and was claiming a large amount of sums, and this was now settled. So, this can be more or less in the favor of the investor or the state. So there are, of course, also unknown cases. Usually the new exit rules, most cases are actually public, so there are not secret tribunals. You can even read the transcripts of the big cases. Also Vattenfalls, the hearings were actually transmitted live, and you could look at them and follow the hearings and so on. So that argument is not really that prevalent anymore. Let's look at the unique element of investor-state dispute settlement, as it's also called, ISDS, because it is a dispute settlement mechanism between settling disputes between an investor of one contracting state. So remember, we're in international law, it's two states, the first BIT being signed by Germany and Pakistan. It's an investor from one state, so a German investor investing, building a port, building a power plant, a dam projects, or mining and so on. Those are classic examples. In another contracting state, say Pakistan, Yemen, or the Swedish investors in Germany, for example, and a dispute arising out of this investment, and then the investor is suing the state on the basis of these agreements. The ground on which they can file a claim are these investment agreements. Mostly those are the BITs, the BITs, the bilateral investment agreements, like US Argentina BIT from 1991. They can also include, so these are the protection standards, for example, against uncompensated expropriation or fair and equitable treatment, national treatment, that you're not discriminating between national and international investors. And if that's violated, then you can file a claim. But there are also the so-called umbrella clauses that allow, not all treaties have that allow that each party shall observe any obligation it may have entered into with regards to investment, to kind of elevate that contractual level onto the international plane and be a ground for a case being filed. So in that sense, it's a unique setting because there is no, previously you heard, you need a dispute resolution clause that provides for arbitration, or the parties, the two companies are agreeing after dispute arises to settle the dispute by arbitration, so alternative to court litigation. But here there is a kind of standing, or at least that's been the interpretation, a standing a consent for any investor who then takes up this kind of invitation to settle a dispute through ISDS. So that's been interpreted very broadly. Also another point of critique that this was actually not intended by the states party to these agreements. So I just want to give you some typical matters for investment disputes that that these disputes are dealing with. So it's, as I mentioned, it's one-sided in a way that only the investor can file a claim against the state. So the most obvious case is uncompensated expropriation. So most treaties provide for the protection against uncompensated expropriation. So a transfer of title, you build a bridge, you build a dam, you build an airport, and so on, and then it's no longer yours. It's being nationalized. There's of course protection for that. It doesn't change any of the law, so states can expropriate, but then of course they have to pay damages and compensation for it. Has to be taken, for public use, non-discriminatory, due process of law, and then you have to give compensation. So it's actually very tricky to internationally in compliance with these rules to expropriate. There are also the so-called indirect expropriation, so where it's not a formal transfer of title, but a kind of indirect way of, you don't get a certain permit, so then you can't use your investment. You get a license to exploit a mining project for 10 years, but then it's being revoked after a year, and so on, or the environmental standards are being increased so that you cannot use your investment, and so on. These are cases of indirect expropriation. Lack of legal protection, so that's usually within the so-called fair and equitable treatment standard, also called FET, so that you protect the kind of legitimate expectations of a stable business environment for these cases, and then also lack of protection against harmful acts. So there are riots, destruction, and the state, is just passive and not helping the investor out. That would also be a violation. A word maybe on the I'll just note the time so that I'm not overly using up your time. As I mentioned, ICSID is really the central institution in that area. The ICSID, International Center for Settlement of Investment Disputes at the World Bank. This is very important. The convention has many, almost all states around the world. And as you know, I said around 1,000 cases have been administered. 830 cases of those have been registered with the ICSID. The advantage being that it, of course, also ensures worldwide and enforcement and recognition of these awards. And the World Bank effect is also something that ensures that, well, you can think about an award in the hundreds of millions or even billions against the state. Well, how do you get the state to pay? Actually, in practice, it works out very well. The reason that's usually mentioned is the so-called World Bank effect, because there's actually a provision there. If you don't honor your obligations through that they can stop giving the country loans and so on. So there is this economic element of it. Briefly, I just want to mention dispute settlement as an example of a treaty provision here that allows the investor actually to choose between the different institutions, and you can see here below any other arbitration institution. So they could also choose ICC and or any other institution as well. Maybe a final point on jurisdiction, which is the matter that is actually very relevant, because obviously not any legal dispute can be brought before the arbitration, before an arbitration tribunal regarding investment. But the ICSID Convention talks about any legal dispute arising directly out of an investment. And obviously, as you can, as lawyers, you already immediately notice that, well, the tricky issue here will be what is an investment, and it wasn't defined in the negotiations, but the general understanding from the jurisprudence that it was developed in the doctrine says that it has to have certain characteristics. This is the so-called Sahani test of a certain duration, assumption of risk, economic risk, contributions of money, and then the more controversial one, a contribution to the host state's development. And that's the kind of outer criteria for what an investment is. And then you still have to look at the specific BIT, for example, that usually has a more clear and more detailed definition of what an investment is. And then, of course, here, it tries to define the term more clearly, but obviously it's then a question of interpretation in some cases where, is this now a investment or not? Right. So maybe to just briefly, I mentioned the treatment standards here that can be invoked, but most importantly, the effect, of course, they're binding, just like an award is binding in commercial arbitration, binding on the parties, and they should comply because they are states. It's, there's another level that you need to pass in the international world. And this is governed by Article 54 of the ICSID Convention that obliges all contracting states, all 155 states around the world, to recognize these awards as binding, as if they were a final judgment of a court in that state. And so there are only very limited grounds that you can annul these awards. So in some way, in broad strokes, similar to setting aside proceedings in commercial arbitration. So only really, manifestly exceeded its powers. There was corruption, serious department of a fundamental rule of procedure. So this is very limited. I want to close with an outlook. So what are we expecting for the field to happen? I mentioned that there has been some critique against the field, that it's too much in favor of investors, that it negatively affects the right to regulate of a state. Check out the episode of last week tonight with John Oliver on Philip Morris. Philip Morris, a very famous case in investment arbitration because they sued for plain packaging regulation in Australia and in Uruguay. They lost both cases. So, the critics mentioned these cases, but then the proponents would say, well, but the system worked because they didn't succeed in these cases, and also the issue of the revolving door of arbitration, that a lot of the individuals are actually the same people who also benefit from the system. So who is an arbitrator and so on, that's also being discussed. So the Untitled working group is now looking at these issues, and the EU has actually proposed a multilateral investment court system. So to replace the kind of arbitration system where parties can choose and nominate, and the institutions nominate their arbitrators, but that they are not arbitrators then for these disputes, one dispute at a time, but that there are actually a standing investment court that will deal with these issues, so you can develop a coherent body of case law, so that there is no incoherence between decisions, which we can see in investment arbitration, which is also the nature of arbitration, that it's a decision resolving one specific dispute and is not concerned with the development of a coherent body of case law. And so there are a lot of proposals out there. We'll see what happens. In conclusion, ISDS definitely provides for effective dispute settlement for investors. The substantive investment law, I mentioned fair and equitable treatment, indirect expropriation. One of the issues is, those are rather vague standards, so they need to be fleshed out through jurisprudence, through arbitral practice. And so one point of critique is also that these areas of law have been developed and interpreted in a way that's more favorable to investors and less so for states, so that the balance is a bit skewed here. So the critique of biases because of these issues, the structural issues that only investors can file a claim, that there's a financial interest of the system because it's a very lucrative system to work within, that's built only on investors suing states. So there is not this two-way element that you have in commercial arbitration. But so the critique is out there. I have some materials on this and suggestions for reading on this further, that you can make your own opinion about the issue. And well, what's already clear from following the discussions of reform, it will take time, but it's a very exciting field, so it will definitely be very exciting for the time to come. So thanks a lot for your attention, and yeah, I'm also happy to answer any questions you might have. Thanks.
Dr. Lentner, thank you so much. Wonderful presentation, very, very good, and I look forward to questions at the end of the panel as well. Yeah. So our next presenter, Mr. Takatori Yoshihiro, is widely recognized and sought after in his field. With vast experience, his expertise is brought to bear to shape, guide, and further the development of this resolution process. Present us with a Japanese perspective. Mr. Takatori, if you would.
Thank you. Yes, can I share the my presentation? Okay. Slideshow. Okay. Sorry for the my delayed joining because due to the big summertime change zone difference, I just realized the computer misplaced the time zone change calendar input. So again, apologize for the inconvenience for the audience and the panelists. So my name is Takatori. As the Philip kindly introduced, doing the cross-border arbitration and the mediation in Japan, in addition to the litigation. So today, I would like to address to the modern arbitration law with emphasis on the Australia and the Japan adaptations and recent developments of the ADR platform in Japan, because we are a lot of the movements and initiatives and facilitation of the ADR proceedings in Japan now. So first page, just a moment quickly. So recent discussion in Japan on the possible amendments of the Japanese Arbitration Act following Arbitral Model Law 2006, which I believe the Dick Eastman explained, including the enforcement of the preliminary interim measures to be issued by arbitration tribunals. Then such is based upon the background of the discussion in Japan. Currently, the facilitation of international arbitration mediation, including the establishment of Japan International Dispute Resolution Center, which is abbreviated JIDRC, in Osaka first, 2 years ago, and then last year in Tokyo, Japan International Dispute Resolution Center was established in Toranomon in Tokyo. And also 2 years ago, the Japan International Mediation Center in Kyoto, JIMIC Kyoto, was established. So while the current Japanese Arbitration Act is based upon the Arbitral Model Law, a few points, including the enforceability of interim measures provided by the 2006 version, has not been implemented. Japanese judicial community, including the Ministry of Justice, Japan Federation of Bar Association, which is called Nichibenden, and Japan Arbitrators, Japan Associations of Arbitration, for which I'm the executive director as well, are facilitating more activation of international arbitration and mediation in Japan, especially for cross-border international cases. And such motivation is pushing forward the possible amendments of the Arbitration Act, including the following provisions on interim measures. And in Kyoto, we have Japan International Mediation Center. One of the reasons is why should be in Kyoto. That's because Kyoto is kind of regarded as a very big sightseeing place, like as a Hawaii, which is a very popular place for the international ADR and mediation as well. So that kind of things are going on in Japan, and that's pushing forward the more ancestral type of arbitration act, which we should have. So I will address on the some concrete provisions on that. So the just for the convenience, for the original Japanese is put on the top, but the first amendment points is the interim measures or provisional measures. Current the Arbitration Act, Japanese Arbitration Act provides Article 24, first provision. Unless otherwise agreed by the parties, an arbitral tribunal may order any party to take interim measures or provisional measures as the arbitral tribunal may consider necessary in respect of the subject matter of the dispute upon the petition of a party. This is very good device for the arbitral tribunal, but unfortunately, they didn't have the enforceable power like the Japanese court. So that's the point which we should amend, which is now under discussion and then would be realized by the recent by the amendment of the Japanese Arbitration Act, which should be realized in a very short future. So, as you know, the and also I believe the Dick Eastman went through the Arbitral Model Laws, very new, very kind of trends of the international ADL. So Arbitral Model Law on International Commercial Arbitration 1985 with the amendments as adopted in 2006, which the now Japan is seeking for the catching on the certain such provisions. So Section 4, recognition and enforcement of the interim measures, Article 17H, recognition and enforcement first, and interim measures issued by arbitral tribunal shall be recognized as binding and, unless otherwise provided by the arbitral tribunal, enforced upon the application to the competent court, irrespective of the country in which it was issued subject to the provision of Article 70I. So this, the application to the competent court can be enforced. That's the point which the current Japanese Arbitration Act lacks. Then we are now discussing on the amendment. So that, the issues include the definition of such interim measures to be enforced in Japan through the Japanese judicial court system, and the scope of the arbitration which can issue interim measures to be enforced. Then current discussion is going on with the Japanese government and the Japanese Federation of Associations and the Japan Arbitrators Associations. The point is, the question is, such enforceability should be limited to the arbitration, the seat of which is only in Japan or not? Maybe we should broaden the scope of such the seats, not only limited to Japan, but also for the international arbitration, because we'd like to facilitate and motivate the users to utilize the international arbitration in Japan, and also Japanese related matters and the Japanese companies involved case should be utilized for the international arbitration. And also Japan should be the place for the so-called third country, neutral country, where the overseas users can utilize the arbitration and mediation, even for the case which does not include Japanese party. That's our goal. So the amendment of the recognition and enforcement of interim measures, the cause of a refusal for the enforcement of interim measures beyond the scope of arbitration agreement or the presentation. Sorry, it's a little bit cause of a refusal for enforcement of the interim measures beyond the scope of the arbitration agreement or of the petition presented in the arbitration procedure. And a dispute may not be subject to the arbitration agreement pursuant to the provisions of the Japanese laws and the regulations, and contrary to public policy in Japan. That's the cause of refusal. And then concentration of the jurisdiction by courts, acceptance of English documents. That's also under discussion, because the Japanese courts and the judges are not so used to the how to deal with the international arbitration practice. So I'm now currently doing the some training sessions to the Japanese judges who should be familiar with the arbitration practice, and just in case for the such challenge case on the refusal of the enforcement or something. So in the such jurisdiction matter, we should limit to the only Tokyo and the Osaka District Court only. That's under discussion now. And also how to train the judges, experience, English capability. One of my role is to do that kind of things also. So needs accumulation of the judicial precedents, consistency, because if the Japanese judges attitude and the stance for the such the cases are not consistent, that could be a problem for the a good platform for the ADR practice in Japan. So then next subject is a Singapore Convention, enforceability of ADR settlement agreement. This is also the point which we are now discussing on the possible amendment, and also the signing of the Singapore Convention. But for the signing such convention, we need to amend the our internal domestic law as well. So whether the Japanese government should sign, sorry, that misspelled, Singapore Convention on enforcement of the mediation settlement or not. This is really a hot discussion now. So facilitation of med with the recent arbitration mediation platform developments, including the newly established Japan International Dispute Resolution Center, JIDRC, as well as Japan International Mediation Center in Kyoto, JIMIC Kyoto. So take initiative for amicable settlement. Just a moment. Maybe I may have more time, right? So yeah, hybrid of a common law type of the facilitative and civil law type of evaluative. That means as you know, the common law type of mediation is a more facilitative, and the civil law type of mediation is evaluative. So such hybrid type of a combination should work. That's also really for targeting at the future nice combination of such cross-border legal culture, and that could be the basis for the such Singapore Convention settlement. So should be limited to the international ADR or include domestic ADR. That's under the discussion. And the reservation opt-in and should be default or opt-out. That means if the party would like to opt in the such Singapore Convention's enforcement power, then that could be triggered for the enforceability. That's one option. And then another option is the default style is the which has the enforceability power on the settlement agreement. Then if the party would like to opt out, then such agreement may not be enforced through the court's power or something. So which is better? So then current trends and the way direction of the Japanese discussion is opt-in direction, but that not yet fixed. So we are now discussing with the Japanese government and such ADL practitioners field. And currently the Japanese Ministry of the Justice is seeking for the public comment for those the how to deal with the Arbitration Act amendment and also Singapore Convention's signing style. So current discussion is quite hot. And then big concern on the possible abuse for money laundering. If the ad hoc settlement agreement can be enforced the overseas and the cross border, then such settlement payment can be utilized for the money laundering. That's a quite bad scenario. So how to avoid, or if we sign on the Singapore Convention, that may triggering the increasing of money laundering. That's a sort of problem, which money laundering's concern was the cited in the newsletter for the Chartered Institute of Arbitrators newsletter, and we are now discussing on that. And then, so how can courts deal with the challenge case and how to determine due process for mediation, and no concept of the seat of mediation. So which is different from arbitration, because we have a concept of the seat of arbitration, but we do not have the concept of the seat of mediation. So even if a challenge case, as you can see in the Singapore Convention, you can some provisions for the obligation as the mediator, but such mediator obligation should be determined which law and what law will govern on the mediation's stance on and also due process or something, because we have no concept of the seat of mediation. That's why that could be quite challenging for the courts. That's kind of a thing is now discussed. So this is my conclusion. And then some points I touched, the Singapore Convention and the possible amendment of the Arbitration Act and recent trends in Japanese ADL field and the practice. That's my conclusion. Thank you very much.
Mr. Takatori, thank you so much. Excellent presentation. We all enjoyed that. And so it seems to me that we've had our panel presentations and looking to see now if we have any questions. It would be very interesting discussions, I think, to follow up.
Professor Jimenez, there are some questions which have come in on the Q&A function.
Yes.
I see 5 of them now.
I see 4 of them, but we'll start at the top. I suspect from the time that we see posted, this may have been Mr. Eastman's presentation.
Yes, there are 2
Yeah.
questions that look as if they came in for me, and it possibly 3. But let me address them here. How do national rules compare to institutional rules like LCIA? I'm not entirely sure I understand the question. National rules might mean domestic arbitration laws, but LCIA has rules which parties can adopt when they ask the LCIA to administer an arbitration, and those rules become part of the agreement of the parties. So that's about as much as I can say about this question. Going on to the next question from Kishore Deer. How far is it beneficial or detrimental to have an arbitration law different from the UNCITRAL model law? Well, it would depend on what the arbitration law said, but as I mentioned, a very large number of countries have modeled their provisions on the model law, and I think it's a very good standard. However, I must say, I pointed out England and France, and I believe also Switzerland, and there are other examples of countries that have not gone with the model law. But on the whole, English arbitration standards, the results that come out of holding your arbitration in England or Paris or Switzerland, all of which are rather popular places to hold international arbitrations, are quite similar, as is the case with holding them in Singapore, Hong Kong, or indeed San Francisco. So I think the bottom line is that there are details of procedure, and most people in the field seem to think that having reference to the courts, such as the English law provides to answer on interim basis questions of law, is not a good idea, because the goal of arbitration is to expedite things, move along quickly, and stopping everything while you ask the court to resolve a question of law is not in the spirit of arbitration as it is practiced today. Now, the third question is a very interesting one. It seems as if it came from a Russian or Ukrainian lady, and asks a challenging question. Is there some short time procedure of arbitration case consideration? For instance, a week, 2 weeks, or a little bit more? If it exists, are there any special rules? And I can answer broadly that yes, there are such procedures. I doubt that any of them get done within 2 weeks. I must be frank, I haven't ever handled a case on an expedited basis, but several institutions have such rules. But even the fastest ones, I think, probably take a month or more, although there are also rules for interim relief, where an arbitrator is appointed simply to give interim relief. And those cases, I think, can be handled in a few days or sometimes are. Now, Takatori Sensei, you have been addressed a question. Can you see it there?
Yes.
Can you,
Yes,
can you see that, Mr. Takatori?
Yeah, I can see the regarding the tours allowing foreign qualified lawyers or not. Yeah, the question is the yeah, Japan is more towards allowing foreign qualified lawyers to act in domestic arbitration. So that's really good questions. And generally speaking, even for the international arbitration, which has some international aspects, the Japanese Federation of Associations and the kind of domestic lawyers have been a little bit kind of against the involvement by the foreign lawyers in the history. And then the recent amendment is a little bit broadening, make it broader of the scope of international arbitration, for which the foreign lawyers can be handling. That means, for example, like if even the domestic companies disputes, such the parties is for example, like a subsidiary of the international company, that should be regarded as the international case. So then our foreign lawyers, the foreign lawyers means the we have a special registration qualification, which is called Gaikoku Hojin Bengoshi, which is registered in Japan, although they are qualified overseas. And such requirement has been quite strict, but some requirements has been a little bit, released. And then together with the such concept of the what's the international arbitration is a little bit broadened, then the current trends is definitely towards to the more broad involvement by the foreign lawyers. But for domestic arbitration, I think the issue is the how you can determine the domestic or international. So if it's purely domestic companies, domestic cause of actions in Japan field, that may be tough. But definitely our direction is more make the Japanese platform should be more international, even for the cases which only utilized by the foreign companies. Our goal is more facilitated over such a practice. So in that sense, I hope such the concept of the international arbitrations, international means should be more broadened, but unfortunately, pure domestic type of disputes could be tough. So we have a kind of dual wheels, and then we are now facilitating it. It's not so kind of clear answer, but that's my opinion. Thank you.
Professor, could I just chime in a little bit?
Please.
On this, the topic of right of audience in arbitration around the world is a rather interesting one. Throughout, in the early days of arbitration, and even now today in many places, you don't even need to be a lawyer to be an advocate in arbitration. The US for a long time was pressing countries, including Japan, but also there were issues in Malaysia and Singapore and elsewhere about letting foreign lawyers in to handle arbitrations there. Funnily enough, the US then became an offender. I wrote an article long ago about a case in California finding that lawyers from New York could not handle a case in an arbitration case in California. There was immediate legislative relief, but it did not extend to international arbitration until last year. And now there is an amendment to the law in effect by which, with some conditions, which are complicated, lawyers from not only New York, but all of the US jurisdictions, as well as foreign lawyers, can handle cases in California, although there's a list of the types of situations in which that is permitted. It's very broad, but it is not universally extensive. So this is an interesting little corner of the arbitration world, which is right of audience in certain countries.
Thank you very much. Let's see, we have an interesting question from Mr. Salgado. And it looks to me as if it probably is a question, the answer of which should be given by Dr. Lentner. Can you read that to Dr. Lentner?
Yeah, so this is basically about Latin American countries developing new policies on protection of environment, how that's related to investment protection, whether that's investment protection can be hindering these policies. And I think that's a classic example, and also of legal and environmental development as a human rights and so on. So that's just briefly. I mean, that's one of the contestations. That's part of the argument of whether and to what extent human rights can be and are considered while deciding on protection standards and claims of investors against foreign states. When, for example, a state decides for environmental reasons to impose measures that negatively affect an investment, and on what basis would that be legal under the applicable investment law. And this is something that is also a classic example. So there's also, because you can remember my first name, Gabriel. So there's Gabriel Resources v. Romania, for example, where it's also a similar issue about a gold mining project, a large gold mining project in Romania, and the dispute going on. There's a recent dispute of the Netherlands deciding to eliminate coal plants or to phase out coal plants. And then in 2015, right when the Netherlands signed the Paris Agreement, a German company, RWE, decided to build and invest new coal power plants. And then, so are these expectations of investors to have continued revenue, and certain expectations are protected by this. So this is, there is some uncertainty to it. And this is also part of the reform discussion, how to get environmental interests, human rights interests more into the discussion of investment protection, because these measures are, in most cases, are an issue for investment arbitration. And so the balance that needs to be struck hasn't been elaborated in these treaties. As I mentioned, they're fairly old. There were no expectations that this will be an issue. So it will be up for the tribunals then to decide. And so it's definitely an issue that countries should look very closely. I remember I talked with the, I think, Deputy Foreign Minister of Panama, for example, because there's an interesting case that I've been looking at involving trademarks. And she said, yeah, their policy is, they're not so happy being sued for certain state measures that they implemented, and they had to pay compensation. So they're not terminating existing treaties, but they will not sign new investment treaties. So it's definitely something that has to be carefully considered. So thanks for the question.
Wonderful. Thank you so much, Dr. Lentner. We have another question here from Ryan Driggs. Would the signing of the Singapore Convention create an opportunity for money laundering? I think that's probably directed to Mr. Takatori.
Yes. Because the concern on that is the purpose or background of the such settlement negotiation cannot be seen on the surface. And if you would like to do money laundering, you can hide such purpose, and then you can make a fake presence by which some certain amicable settlement is reached. And then you can utilize, for example, the Japanese court power for money transfer, like from China to Japan or whatever. Then if you pretend to be one of the party is Japanese party is objecting against on the performance under the such settlement agreement, then Japanese court can enforce. So the problem is the mediation is more utilizing kind of ad hoc style, and then you do not necessarily disclose the purpose or such background. So then if the bad guy is going on, such money laundering purpose can be utilizing the such money transfer device. That's the concern, I think.
Thank you very much. It looks as if the next question from Ms. Deer is directed to, once again, Dr. Lentner.
Yeah, thanks. So what is the status of ISDS reform? So there is a broad discussion at Untitled, so the UN Secretariat, and I mean it's ongoing. It's a a diplomatic process. They want to bring in all states and stakeholders, and the discussion. Yeah, I mean it's. It looks like there are the proposal by the European Union and kind of the introduction of an appellate mechanism. There is the idea of a multilateral investment court that would replace the individual, the arbitration system of that ad hoc basis, and so on. In my personal opinion, what I'm hearing from the discussions, I don't think the EU has that much influence in that regard. I think it's a very not many states are on board, and so yeah, I think it's interesting. There will definitely be reform, and we already see it in new treaties that they are tweaked here and there. But I don't expect a revolution that is taking place in ISDS reform. I think some of the critique is very well taken, and the new treaties are adapting to it. But as I mentioned, there are 3,000 treaties out there. There are multilateral treaties out there. They're not going to be changed just with a broad brush and that easily. So it will take some time. It's ongoing, and I think it's interesting to follow.
Thank you very much, Dr. Lentner. Are there any of the other experts that we have before us who would like to comment? Feel free to chime in on any of these questions. And this one looks as if it's directed to Mr. Takatori. Would the Singapore Convention make mediation popular method of commercial dispute resolution?
Yeah, my short answer is yes, and because if the Japan can be regarded as the good forum for platform for the such enforceability of amicable settlement overseas, then such settlement negotiation and the settlement mediation process can be more reliable than just the parties' agreement. But someone's saying is the amicable settlement is amicably agreed. So then the percentage of the such non-performance due to the under the settlement agreement is a very low percentage. And then as I touched on the money laundering concern, whatever. So for such very, very small percentage possibility of rejecting, why we need Singapore Convention. That's kind of a discussion is from the, especially domestic ADLs practitioners or something. But still, to keep and increase more reliability of settlement agreement through the mediation. I think that's could be useful. And in other words, if the Japan is not signing the Singapore Convention, that may be some obstacle for the making the Japan as the good appearance and a good looking for the dispute resolution. That's my answer. Thank you.
Thank you very much. Our next question asks, do you think that the new reforms in Mexico's law restricting dramatically energy's production will end up in ISDS? I don't know.
Well, brief answer, because I know we're short on time, would be what you should be looking at is the fair and equitable treatment standard, which usually is interpreted as protecting the legitimate expectations of investors in a country. So that's definitely something to look out for. I'm not too familiar with the specific context. Energy is a big issue in a number of cases, also against Spain. So maybe look at the cases there, also Italy and so on. So those are also classic cases. Of course, you have to look at where the investors are from, the nationality of the investors, because that then determines whether you are actually under the protection or the foreign investors are under the protection of the bilateral investment treaty, which usually will have ISDS, and then there is a possible avenue depending on the measures of the state and how they're implemented. Thanks for the question.
Thank you very much. It looks as if we are out of time, and I'm really sorry to have to terminate this wonderful presentation and discussion. We've all learned a great deal. It's been very productive, and thank you, gentlemen, very much. And I look forward to the balance of this all-day symposium. Thank you.
Thank you.
Hi, everybody. I would like to chime in and just send another thank you to all of our panel one speakers and moderators. That was very, very informative. And I know we've crunched in a lot of information in such a short amount of time, but we want to thank you for joining us. We really appreciate your time, and we're so honored to be able to host you. I would like to remind everybody that our next panel will begin at 2:40 in just a few minutes here. Please note that your questions are saved in our Q&A, and we will be able to refer to them after the event. So thank you for sending those in.
Hello to my fantastic panel. We are online, but it looks like we'll get started in a minute or two.
Hi, Gary. Thank you. Can you hear me okay?
Perfect.
Hi, Gary. Hi, Nancy.
Hi, Luan.
Alrighty, welcome everyone. Welcome back from the brief break that we just had. Hopefully we can just get started. Please allow me to make the introduction to the second panel of our event. The topic of the discussion for this panel will focus on the procedural analysis on the issues of arbitration proceedings, with discussions regarding arbitration agreements, selection of arbitration seats, diversity initiatives, and information exchange methods. I will now hand it over to Mr. Gary Benton, the moderator for this panel. Mr. Benton.
Thank you so much, Kwa, and my congratulations to you and Michael and Jackie and Melina for just a wonderful program, seminar that you've organized for all of us. So hello, everyone. I'm Gary Benton. I am an international arbitrator here in Palo Alto in Silicon Valley in California. I am also the founder of the Silicon Valley Arbitration and Mediation Center, which is a nonprofit that provides educational resources to the global tech sector. But my most favorite title, my most important title, is that I am an adjunct at Santa Clara University. So when you hear people talk about who is that really great professor who teaches that international arbitration class, and he's just so brilliant and handsome and engaging, that's me. That's me. So I want to share with you, though, some even more engaging people that we have with us. Before I do that, let me, in addition to extending my thanks to the Journal of International Law board and its editors, also a thanks to Professor Jimenez and Dick Eastman for their leadership and inspiration on this seminar. I've seen it all put together, and they've done a real wonderful job. And also a thank you to Professor Sloss, who will be moderating the next program. And Professor Sloss brought me into the Santa Clara community, and I appreciate that. We've been talking a lot about theory. You heard from Professor Jimenez, Mr. Eastman, about the treaties, the laws that apply in international arbitration. You heard from Mr. Takatori on how one country, Japan, a very important country, the second largest GNP in the world, is implementing international arbitration. And you heard from Professor Lentner about investor state arbitration, one variant of international arbitration. For most of the rest of the day and the next panel, we're going to be focusing on the other variant, commercial arbitration, and we'll be talking about a lot of practical instances and how that is applied. Let me just begin, and I will end as well with this thought. What I always share with my students in my international arbitration class is that international arbitration is a pretty majestic creature. And what do I mean by that? What I mean is we are so divided in the world politically, culturally, geographically. There are many hundreds of jurisdictions around the world with their own courts, each enforcing their own judgments. But somehow, through this real majesty of treaties around the world, most particularly in the commercial sector, the New York Convention, we're able to provide for a peaceful resolution of international business disputes. And that is something that is really quite phenomenal, and it makes it a very fascinating and enriching area of study. So let me now introduce, if I can, our panel. I'm going to screen share a little bit so you can all see names as well. There we go. And I am very, very fortunate in having an amazing panel with me today. Let me tell you who they are. So first of all, Professor Victoria Shannon Sahani, the Associate Dean for Faculty Development at Arizona State University, the Sandra J. O'Connor School of Law. Professor Sahani is well known to everyone in the international arbitration community. She has a long career. I think actually way back when at my alma mater, the Pillsbury Law Firm, but perhaps more importantly, Victoria, you've done a lot of work over the years with the ICC, and you continue to have important committee roles. On the academic front, Professor Sahani is really perhaps the expert in the world on third-party financing. She's done a lot of work on that and other areas of international arbitration. So thank you so much for joining us. As well, my colleague Nancy Thevenin from New York. Nancy is the General Counsel of the USCIB, which is the serves as the National Committee for the ICC Court of Arbitration. Nancy is a well-known international arbitrator in her own right, as well as an adjunct professor. And she has done some amazing work in a lot of fields as well. One of the most areas that she's focused on quite a bit lately is on diversity. We're going to be talking a lot more about that. So welcome, Nancy. And last but not least, my old friend and colleague, Luan Tran from King & Spalding. Luan is a partner there. Those of you in the field know that King & Spalding is often rated as the #1 in international arbitration. And so a really great firm with activities all around the world. Luan in particular has focused many years, not just on California, but on Southeast Asia, spending significant time in Singapore and focusing quite a bit on Vietnam. And he is truly a trendsetter, as he's been called many, many times. So Luan, thank you very much for joining us. All right. With that, let me share with everyone the topics that we're going to be addressing today. And you can see them there. What we're going to do is give you an overview, a glimpse of some of the important practical process areas of international arbitration. It'll be a quick glimpse. If you really want more, if you're a Santa Clara student, you'll take my class and have a whole semester in it. But I think what we're going to do is really cover some of the hot topics and fundamental topics that come up. So Professor Sahani is going to share with us a little bit about ADR, international arbitration agreements, the sort of fundamental core of the process, bringing together some of the earlier discussions we've already had. Then Ms. Thevenin is going to talk about international arbitration seats, institutions. Mr. Tran is going to talk about arbitrator selection and diversity, as well as information exchange, what we in the US inappropriately call discovery, and judicial assistance. And then we'll wrap up talking about arbitral proceedings. It's going to be a little bit of a discussion. We'll have our lead commenters sort of open the discussion and everybody else will join in. So with that, Victoria, if I may, I will turn it over to you.
Thank you so much, Gary. And wow, what a blast from the past that you remembered that I practiced at Pillsbury a very long time ago. So it's so kind of you to remember that detail. And it's a pleasure to be with you on this panel, along with my colleagues, Nancy and Luan. This is a really great opportunity. And thank you to the Santa Clara Journal of International Law for inviting me here today. So starting us off here with the topic of sort of an overview of comparing these various dispute resolution mechanisms that are used in the international dispute resolution arena. We have the term ADR in the title of this topic. And here in the US, sometimes we call that alternative dispute resolution. When I was at the ICC, we called it amicable dispute resolution, but whatever you'd like to call it, that is the acronym for things that happen outside of court. The idea here is we are engaging in a dispute resolution process that does not require a judge or jury. Within that larger umbrella of ADR, you have a variety of processes, including arbitration, of course, as well as mediation, negotiation, conciliation, dispute boards, and there's all sorts of other types of structures for those dispute resolution processes. And I just want to give you a really quick comparative overview of what those sort of look like. And then I'll talk a little bit about the pros and cons of international arbitration. So under the ADR umbrella, you can sort of think of a continuum or spectrum from sort of more informal to more formal dispute resolution processes. So on the really formal end, you would have, of course, court litigation, as well as arbitration. Arbitration is very formal, it's very adjudicative. It's not necessarily as formalized with the power of the state as the court is, but it is almost there, right? And it uses the court as sort of the backbone to create legitimacy for the arbitration process. And of course, in arbitration, you have an adjudicator. You have a third party neutral to the case who is actually deciding the matter. And then from there, it becomes less and less formal. There's a process called mediation. Mediation is where you still have a third party neutral that is involved in helping the parties to reach their own settlement. So that's a different posture for that neutral, as opposed to that neutral deciding for the parties. Instead, that neutral is helping them decide for themselves. Sometimes mediation is called facilitated negotiation for that reason. And then, of course, you have conciliation, which, depending on whom you're talking to in the international space, looks more like either a heavy-handed form of negotiation where you have a conciliator that is helping the parties to reach some sort of agreement, settlement, compromise, similar to mediation, but often less formalized. And then you have negotiation, which anyone can negotiate, of course. You don't need a neutral, you don't need a third party to be involved. And we all, in our day-to-day lives, we negotiate all the time with our friends, our family, with businesses, et cetera. So negotiation is the least formal if you go along that spectrum. Dispute boards, which I mentioned a little while ago, are often used in construction cases in the international arena. And they are closer to the adjudicative end, closer to what an arbitration tribunal would look like. The difference with a dispute board is it's a standing body. So it's the same set of adjudicators sitting in that role and hearing multiple disputes in the course of a project, like a construction project. So that's a little bit of an overview. There are actually a lot of other types of ADR processes out there, like mini trials and other types of mock settlements and things like that you can do. But for international purposes, it's typically we're talking about negotiation, mediation, arbitration, maybe some dispute boards, and maybe conciliation, particularly if there's a state involved. So pros and cons of international arbitration in just the couple minutes I've got left here. Gary has done a wonderful job putting together these slides. Thank you so much, Gary, for taking on the lion's share of the work on that. And he has really encapsulated in this list he has here, what are the main issues that parties are thinking about when they're trying to decide, do I choose arbitration, international arbitration, over, say, litigation or one of the other processes? Time. What control do I have over time? Can I make it quick? Sometimes parties actually want it to take a long time, particularly if you're on the defendant side, respondent side, you may actually want it to take longer, but most of the time parties are looking for it to be short. And so time is something that you can, to some extent, have a little control over in international arbitration, particularly if you write some sort of time constraint into your clause. Cost. Sometimes arbitration is cheaper, not always, depending on a variety of circumstances, but that is certainly a consideration as to why parties might choose arbitration over litigation. Expertise. In litigation, you don't choose your judge, and you will have to educate your judge about your particular industry or your particular matter. Whereas in arbitration, you can select arbitrators that actually already know that industry or know about that subject matter, and so they have that expertise. Party autonomy and flexibility. Parties get to decide what their procedure looks like within some of the constraints of the arbitration rules that they select. And we'll talk about rules, I know, later in this session. But within those constraints, there's a lot of party autonomy and flexibility, particularly with respect to choosing who the arbitrators are. So that's something that's very beneficial and different from litigation where you can't choose your judge. Privacy, and just to distinguish that for the students in the audience, if you haven't taken professional responsibility, privacy and confidentiality are not the same. Privacy just means that the public can't show up in your hearings. They can't participate and be in part of the audience in the process. Confidentiality has to do with what information can be shared, and parties can agree to confidentiality if they wish to. And then finality, with litigation, you have a bunch of appeals. Arbitration, you don't, you have an award, and then you start to go through the enforcement process. So that helps with the speed, that helps with sometimes also cost if you can get it done faster. And then finally, neutrality and international enforcement. Many parties have what's called a home court advantage if they are going to the court of party A in their home country or party B in their home country. And so by picking a neutral third place to be the seat of arbitration, you have that neutrality aspect, which is very attractive. And then international enforcement, the New York Convention or the Convention on the Recognition and Enforcement of Foreign Arbitral Awards is one of the main ways that arbitral awards are enforced in over 160 jurisdictions worldwide. It's one of the most successful conventions ever to come out of the United Nations. And it's the major framework for why international arbitration works, and in some ways can be much more attractive than court because it's easier to get an arbitral award enforced. So I will stop there. That's a really, really quick overview, and I'm happy to answer questions if anyone wants more detail. Thank you.
Thank you so much, Victoria. So I had some questions actually on I was hoping all of you could just answer in terms of sharing with the audience. So let me, one is a domestic question and the other is an international question. Let me start with a domestic question, one for the US audience. And that is, in the US, sometimes arbitration generally has a bad name, particularly consumer arbitration, employment arbitration. These are types of arbitrations that many countries don't even have. But now Congress has the FAIR Act the FAIR Bill to be reforming that. Just contrast for us, what's the difference between those types of arbitrations and international arbitration? Whoever wants to, please, Victoria, yeah.
Oh, I'm sorry, but please others chime in. I think one of the biggest issues is how the consent comes about. International arbitration, it's often business to business or business to government, and there's really no surprise international arbitration. If you've got an international arbitration clause in your contract in advance or in your treaty, if you're proceeding under treaty arbitration, it's there. There's a possibility there's going to be a dispute. Whereas often in consumer arbitration in the United States, these clauses are included in things like cell phone contracts, cable agreements, medical bills. You might sign something at the hospital when your loved one is admitted and it has an arbitration clause in it, and you didn't even know. That's the reason why employment is another big example. That's the reason why it's so controversial in the US, because a lot of citizens, private citizens, are being forced, what they view as forced into arbitration when they didn't even know the clause was there. So that's why, and that's where one of the things that the FAIR Act is trying to combat.
Okay.
Right. And I do think, if I may, Gary, that it is an issue, to echo what Victoria said, in business to business arbitration, both parties have the possibility to negotiate, even if one of the businesses has more leverage than the other. And in the consumer context, you don't see the appearance of leverage. The leverage is all on one side. There's also a cost. International or arbitration is a private process, and it costs money, the party's money. And so when you're in a consumer context, you don't have, for example, the multi-million or billion-dollar cases. Sometimes there's smaller cases, and then you get into issues of class-wide arbitration. I just think, what Victoria said about the FAIR Act, Arbitration Act, trying to resolve a lot of those issues, I think it's giving Congress or the society a look at a very good dispute resolution mechanism but is it the way it appears in the US, is it fair to all parties involved? And you don't have the same context in the international side.
Okay. Let me just quickly ask the other international question. I do see there's a question that came in from the audience, which we will cover a little bit later in our Q&A session today. But just to sort of bring this full circle on the international side, the topic of neutrality and international enforcement, that seems to be rather distinctive in international arbitration. Would one of you please just comment on that a little bit? What is the concept of neutrality? I mean, to me, it really means fairness, but I'd like to hear your thoughts on how it fits into the process.
Give it to Luan.
Luan, did you want to jump in here? Or?
Luan?
Can you go ahead? I'm sorry, I was preoccupied with something
Oh,
else.
no problem. No,
Okay.
I just wanted to make sure we brought you in the conversation if you wanted
That's
to.
true.
Yeah, so you're absolutely right, Gary, that the neutrality question, it's interesting. There was a time in the past when, and I would say this for many of us, this might be viewed as a distant past. For some of us, it might be viewed as recent. But this idea that the partisan arbitrator, right? A party got to select an arbitrator, and when they selected that arbitrator, there was sort of a wink and a nod that arbitrator was going to be looking out for that party's interest. This was sort of an expectation if you go back in history with respect to arbitration. Nowadays, there's a presumption that no matter who selects that arbitrator is going to be neutral as to both parties. And I think that's a revolution, right? If you think about it, that's pretty amazing. Considering that arbitrator is being paid by the private individuals. But that is something that's very attractive in the process because it's supposed to be quasi-judicial. And of course, the judges have to be neutral. And so we want arbitration to have that same legitimacy. So that's a big part of it. And then that feeds into enforcement because it gives the process more legitimacy and therefore the award more legitimacy. So when you then go take it to a national court to have it enforced, they feel that was rendered in a valid way by a neutral third-party adjudicator.
Yeah, and if I may add, Gary, in the international context, all arbitrators were always deemed to be neutral. So even though both parties get to nominate co-arbitrators and then those two nominate a chair, the obligation was that all three of them were supposed to be neutral. And what they bring in would be a cultural perspective that's needed on the tribunal. Sort of like a translation, for example, things that may be lost in translation in the evidentiary hearing process. In the process itself, your job was to make sure that that party was understood, their cultural perspective was represented, but not necessarily that they would be advocates for the party as it was in the domestic context, which was fairly recently that the AAA with the ABA came out with ethical rules saying, now in domestic arbitration, everyone, all the arbitrators are supposed to be neutral. And that also feeds back into the enforcement, as Victoria started saying, because under the New York Convention, one of the grounds for setting aside the arbitral award is the lack of, or the partiality or lack of independence of one of the decision makers. So it's a very important thing.
Great.
I might jump in very quickly on a neutrality issue. That is definitely an aspiration, but the reality, the practice is when you select an arbitrator, you tend to select someone who you know, either from past experience who knows your work, because obviously credibility is very important. And international arbitration in particular, it's still a very small club, right? So, I mean, if you have someone you've dealt with in the past who know your work, who knows your firm's work, and definitely it's a big advantage for you when you have a close call, or at least at a minimal intimate credibility when you make your presentation to that particular arbitrator.
Okay, and we'll come back to this topic of arbitrator selection and cover it in some detail. I guess the last thought on this too is often neutrality is associated with having an arbitration in a third neutral jurisdiction. And I know that the rules will often encourage that, but I think as a practical matter, more and more as time goes on, people are comfortable, in jurisdictions that are recognized as being fair, and that's where they're held. Let's turn though to the next topic, which is the International Arbitration Agreement. I mean, it's really the core of an international commercial arbitration. You can't have it unless you have an agreement. Victoria, give us the rundown on that, please.
Sure, absolutely. And I'll try to be as quick as I can in the few minutes I have to discuss this very large topic. So happy to explore this further in Q&A. So let's start with the big overarching theme, which is we are only talking about written agreements. And the reason for that is in international arbitration, in order to have your award enforced under the New York Convention and all the other enforcement related conventions, the agreement has to be written. So you're not going to arbitrate on just a handshake or on goodwill. You're going to definitely have a written agreement. So to start off with sort of the types of written agreements out there to arbitrate, the two major categories are pre-dispute and what we would call post-dispute or submission agreements. And so the idea is a pre-dispute clause is, the clause that you see in a contract that you might sign. For example, your cell phone contract probably has an arbitration clause in it. That's a pre-dispute arbitration clause. Or two businesses that have decided to enter into a transaction will add into the contract that they're signing an arbitration clause. That means they don't have a dispute yet. They might have one in the future. That's a pre-dispute arbitration clause. The majority of international arbitrations proceed under pre-dispute agreements. Another example of a pre-dispute agreement that's not contained in a contract is under investment treaty arbitration. You have in the treaty itself an offer to arbitrate by the state, and that offer is then accepted by the claimant, who is an investor, when they file the case. And as you know, law students from your contracts class, offer plus acceptance equals contract. So you sort of have a creation of a agreement, almost like a submission agreement, at the moment that the investment arbitration is filed. Additionally, business to business parties can also, after a dispute has arisen, decide at that moment to submit to arbitration, enter into a written agreement and submit their case. That's called a submission agreement. That's a post-dispute arbitration agreement. So what about validity? The intent to arbitrate is crucial. Any court, and this is often where it comes up, in court, if one party's challenging the arbitration agreement, or it could be challenged before the arbitrators on a jurisdictional challenge. But when a party is trying to object to arbitration, almost the first thing they'll say is intent. I did not intend to arbitrate. I did not sign an arbitration agreement, or what this language says is not evidencing my intent to arbitrate unequivocally. And so that's crucially important. So you have to make sure that within your arbitration agreement, that you have a clear and unmistakable intent to arbitrate as represented by the words of the agreement. And you also want to make sure that the subject matter is capable of being arbitrated. So they call that arbitrable or arbitrability. So certain things, for example, criminal matters in almost every jurisdiction in the world cannot be arbitrated. So they are non-arbitrable. So you need a clear and unmistakable intent to arbitrate and a subject matter that is arbitrable. And if one of those is missing or some element of those is missing, you have what's called a pathological clause. Pathological, as the name suggests, means there's something wrong with it. It is defective, it's problematic. Sometimes those defects are fatal flaws, meaning you can no longer arbitrate under that agreement. Other times they can be reformed or interpreted by either the arbitral tribunal or by a court interpreting the clause to allow arbitration to proceed. It depends on the type of defect that you have. Some of the most common defects are inconsistency, where the clause it has an internal inconsistency where it has parts that cannot coexist. You can also have uncertainty. So there's certain terms in the agreement that are uncertain. For example, if you try to designate arbitration rules, but you write the institution's names wrong, the institution might be unclear whether you agree to arbitrate under those rules of that institution. And then inoperability. Most common inoperability means you just can't carry out the agreement. So that most commonly comes up, for example, in clauses where they name a person. The arbitrator shall be X person, and that person is unavailable, deceased, etc. That's inoperable. So those are some of the common categories There's a lot of examples of these out here that you can find in the internet and in books. Quickly, a few key drafting considerations. Tiered dispute clauses. Sometimes you'll have a clause that has mediation, then arbitration, or you might have negotiation for some period, then mediation, then arbitration. Those are valid and enforceable through all those stages. So those are often invoked. Institutional versus ad hoc. Institutional just means you have an institution overseeing, administering, keeping an eye on, helping with the case. From an administrative perspective. Ad hoc means you're on your own, and most parties are not going to go into ad hoc arbitration unless they're very sophisticated and have been through arbitrations before. The most common ad hoc rules are the UNCITRAL arbitration rules, although there are others out there. I think CPR also has some ad hoc rules as well. And then rules. You always want to pick rules. I've almost never seen an international arbitration clause that does not designate some institutional rules. You do not want to try to write your own rules for international arbitration, and there's plenty of them, plenty of options out there from which to choose. Seat, choice of law, and language. This is about your place of arbitration, your legal place. And now in the sort of jumping ahead a little bit, in our pandemic times, we have virtual hearings. That does not change the seat, legal seat of arbitration. That has legal significance in terms of the court that can set aside the award for a defect, or where you might go for aid in the midst of the arbitration, say for an injunction or subpoena or things like that. Choice of law, what law is going to apply to the subject matter of the case. Language, what language are you going to be speaking in the arbitration? What language is the documents going to be in? Does there need to be translation? Things like that. Number of arbitrators, not absolutely essential, but most arbitration rules actually do include a default for the number if you don't include it. Most of them, for cost reasons, you want to have a sole arbitrator, and you can only get 3 if you explicitly ask for 3 under most rules. And then information exchange and confidentiality. This is a big one, particularly in the digital age. You want to make sure you've got your cybersecurity protocols in place so that you're protecting information and making sure things remain confidential and free from hackers. And of course, video conference hearings, we've all been doing those. I've been involved with those. I don't think they're going to go away even when we get past the pandemic. So I think that's here to stay because it also has a lot of cost savings for clients. So that's a really quick overview, and I will stop there. Thank you.
That's great, Victoria. And before we leave this topic, just a quick question for all of you. I know there's controversy among companies and law firms in terms of whether you should include a tiered dispute resolution in an arbitration clause. Should you have mediation followed by arbitration, or should you have direct negotiation followed by mediation? What do you guys recommend? What do you think is best? Do you just go right to arbitration, or do you want to include some sort of mediation process beforehand?
I would recommend including it, because sometimes when you're in a dispute with another company, it is very difficult to be the first one to suggest that you negotiate further or that you mediate. So that if it's in the agreement, then the parties are much more willing to comply with the provisions of the agreement, especially if it might be considered a jurisdictional issue if they did not. What is important in the drafting of such tiered clauses is to have very clear beginning, when will they be triggered and when do they end? So you say, one of the parties has to notify the other party that there's a dispute, and that starts a 30-day or 60-day period for negotiation, after which the party shall have 60 days from X date to mediate, unless they extend it. What normally happens is if you just say we're going to negotiate and mediate and then arbitrate without such clear beginning and end provisions, the party, when you go to arbitration, they could say, well, the case is not right for arbitration because we didn't do this pre-dispute ADR. Sorry.
Okay, fair enough. So Nancy, let's dig into topic number 3. So arbitration seeks, institutions, and rules. I mean, now we're talking about where should we hold our international arbitrations and which institutions should we use? Look at all those acronyms on that chart. Give us the rundown on all of this.
Thank you. I'm actually going to be piggybacking on Victoria's presentation, which was excellent. Thank you, Victoria. So to follow on what Victoria is saying, Gary, I'm going to take the topics in your slide a little backwards to start backwards. We're going to start with, we'll start with the institutions and rules, right? So Victoria started talking about drafting your arbitration clause, and she briefly mentioned the institution and rules. And she also described for you the difference between ad hoc, pure ad hoc, which is not done, ad hoc under mostly the Untitled arbitration rules, and then of course, institutional arbitration. Now, why would you select institutional arbitration? Well, because the institutions oversee the arbitral process. So it's very important to understand that the institutions do not decide your dispute. It is the tribunals that are put in place, that are selected in accordance with those institutional rules that decide your dispute, but the institution oversees the process. It's recommended in international arbitration because many of these institutions are well respected with tested rules and are given a lot of respect and deference in courts around the world. Now, when you are drafting your arbitration clause, you will say, for example, let's say, for example, you will have ICC arbitration or arbitration under the ICC rules, under the rules of the International Chamber of Commerce, International Court of Arbitration. Or you will have, I will select LCIA, which is the London Court of International Arbitration, or the AAA ICDR, the AAA American Arbitration Association, the International Center for Dispute Resolution is their international arm. SIAC stands for the Singapore International Arbitration Commission, if I'm not mistaken, and then HKIAC, which is the Hong Kong International Arbitration Center. Those are very well-known institutions with excellent staff helping the parties and the arbitrators manage the case. The institution provides the framework for the process to move forward. So they provide rules for how the request for arbitration should be filed and how the response should be filed, and how the arbitral tribunal is selected. And what you'll see in all of these institutional rules is that they're gap fillers. Victoria started by saying that arbitration is a creature of contract. It is a creature of consent. And one of the key advantages of arbitration is its flexibility. So all of these institutional rules preserve that. They provide mechanisms for helping the process move forward efficiently and effectively where the parties fail to make a decision, where the parties fail to act. For example, if the parties can't agree, so you'll see. Otherwise, if the parties agree, unless the parties agree otherwise, X will happen. What's important there is that when you're drafting your arbitration clause, always make sure that the rules you select match the institution. And that is under one of the categories that Victoria mentioned. And I think some people might call it uncertainty, others might call it inoperable. But if you choose ICC to be the institution that decides, that will administer your arbitration, you must choose ICC rules. LCIA, LCIA rules. So you don't mix it. You don't say LCIA to administer ICDR rules, because the institutions, although the rules are somewhat similar, they are very different in how they operate. And we can just go into institutions so much because there are so many all around the world, several in Asia. And I think when you're deciding which institutions to select, you need to determine how many years they've been in existence, their experience, how they, the panel of arbitrators. Some have closed list of arbitrators. Others, like the ICC, will allow you to select your arbitrator under certain circumstances, given that they're independent, impartial, and available. But you really need to be careful, especially nowadays. There are so many arbitral institutions, and I highly recommend you do your research. And if it's a decision between 2 or 3, write a chart and start saying, how are the seats determined? How are the panels put in place? Who are on the panels? What is the cost? at the end of the day, you will decide it based on reputation, professionalism, and cost. The cost is a big determination, a big factor, I think, for parties. Now, the rules, again, we talked about the rules in the institutions, they go hand in hand. They have to be together, and the rules are operated by that institution, and the rules are drafted in such a way, as you start comparing the different rules, you'll start seeing the differences between the institution. Which then, now that you've chosen your rules and the institution with matching institution, now the seat. What is the importance of the seat? Victoria already gave a brief summary of it, and the seat is key. And it reminds me back to my first ICC arbitration case, where the parties decided that the seat of the arbitration will be Hawaii, which was wonderful. Hawaii is hot, but that is not what you should be looking at, a place for everybody to go to have a good time at all, because there are some legal ramifications of the seat, as well as some practical ramifications. The legal ones are, it determines, right? The seat is the juridical identity of that arbitration award. And some people might quibble with that definition because it's international. It should be an international award, but the seat really does determine the jurisdictional identity of the identity of the award, because only at the seat can that award be, for example, set aside under the New York Convention, or if the award was set aside at the seat, you will have difficulties getting that award recognized and enforced in other parts of the world, in other countries around the world. So legally, the seat determines the applicable national procedural law, the form and definition of the arbitration agreement, whether or not the claim is arbitrable, which Victoria mentioned, whether national courts support or interfere with your arbitration, whether enforcement is available under the New York Convention, and the legal seat may also influence the character of your proceeding. You'll see a lot of the fact that if your seat is in the US, your arbitration may have some US characteristics to it, not the plenary discovery or anything like that, but you may have US arbitrators or foreign arbitrators based in the US. So in looking at the seat, you need to see, to summarize, what you should be looking at, you should be looking at whether they're signatories to the New York Convention, whether they have a modern arbitration statute. Modern arbitration statute would be a jurisdiction that has adopted, for example, the Untitled model law, not necessarily, right? Because New York hasn't or London hasn't, but an arbitration statute that is developed and recognized. You'll also look at the practical considerations. Are you able to represent your party in that jurisdiction? Do they require you to be licensed, or do they require the arbitrators to be licensed in that jurisdiction? Does it have good infrastructure? For example, in a lot of the Caribbean, where I do a lot of my work, you won't necessarily have great seats if you don't have 24-hour electricity. There are some practical considerations. How many people will need visas? Is it a place that's very restrictive with respect to other nationalities coming in? So there are practical as well as legal implications for the seat. And I'll stop there unless you have any questions.
That's great, Nancy. Thank you so much. And I do have, a question that maybe Luan would best, be able to help us with. Here we are in California, and California looks really much more to Asia than it does across the Atlantic to Europe. So fill us in a little bit briefly, just about how Asia fits into this. What are the key seeks there? What's happening, and how does California tie in as well?
I mean, there's more and more action in Asia recently for one simple reason. The economic growth in Asia. I mean, they have the world's fastest growing economies for probably the last 20 years, not just China, but Japan, Korea, and now Southeast Asian country, including Singapore. California is a very unique position. I think there's in recent years, there's a big push to make California as a more desirable seat or venue for international arbitration, because the criteria that Nancy was talking earlier about the legal and practical items. I mean, California checks all the boxes. You know, we have a very pro-arbitration judiciary and legislation. We have sophisticated judges here and counsel, and we have a lot of major corporations, especially in the tech industry, located in California. We have the connection with Asia, as you mentioned, Gary, and also, you know, we have all the infrastructure to have to conduct, you know, international arbitration, and then we have a very good, again, sophisticated judiciary that might be needed to, you know, to either injunctive relief, interim relief, or, you know, post-arbitration relief that the party need to seek. So California definitely on the way up. I think that the key is to convince the clients, the corporate companies, to pick California as the seat of arbitration in any potential arbitration. That, I think, is the key, but it's definitely in a good position.
Okay, great. Yeah, you know, it's interesting in that, you know, we've listed here on this slide the top 5, you know, institutions that we typically look to, but of course there are so many others that are significant in the world. CTAC, of course, in China has more arbitrations than any institution, but particularly in Asia, it is such an amazing dynamic place. And we heard earlier about efforts to build up the arbitration practice in Japan, but already there's significant activity elsewhere in Asia, in Korea, in Vietnam, in Malaysia, and of course, India is a developing dynamic that we will be seeing a lot more of, I think, in the next decade or so. Okay, with that, let's Luan, if we can, turn to the next topic, which is arbitrator selection and diversity. We've already sort of touched on this a little bit in terms of selection, and I'd like you to sort of lay it all out for everyone. But even more importantly, we want to talk about the topic of diversity, because I think it's a given that you cannot have a quality arbitral process if you don't have a diverse panel that can assist with good decision making. So fill us in on all of this, please.
Yeah, the most important decision in your case is the selection of the arbitrators. And for the obvious reason that, you know, you're picking the person or the persons who will decide your case. You know, in US litigation, we have, you know, talk about the importance of picking the jury, you know, selecting the jury. But I think it's even more important in international arbitration, because unlike US litigation, in international arbitration, you don't have a judge or a court of appeal to review the jury's decision on the merits. So that's highlight the importance of selecting an arbitrator. Now, let me start with the diversity first, because, you know, it's a big topic right now in the international arbitration community. You know, diversity obviously is not only the right thing to do, but also it's the smart thing to do in international arbitration, especially international arbitration, because we deal with parties from different countries, different cultures, different legal system, and the arbitrator should reflect that, right? Unfortunately, you know, compared to the US litigation, I think the situation in terms of diversity is much worse in international arbitration. There's this expression that refers to the lack of diversity in terms of arbitrators in international arbitration. It's called pale, stale, and male. You know, basically, you know, very small circle arbitrators, especially in the larger cases, consist of, you know, white males from certain European countries, you know, and the likes. So definitely diversity is a big problem. You know, according to some statistics, and we're talking about not just the ethnic diversity, but also gender diversity. According to some statistics, only between 10 and 25% of the arbitrators are women, you know, in the major cases. And I think the numbers are even worse in terms of ethnic minority diversity. There's a reason why the major arbitral institutions, they don't release that statistics regarding the ethnic diversity of the arbitrators, because they know the numbers are terrible, right? You know, there's recent years, there have been a lot of efforts to redress the situation. You know, there are the arbitral institution recognize that. You know, you probably heard the controversy with Jay-Z, where he was involved in arbitration with the AAA, and I think he challenged the panels that were presented to him on the ground that none of them the proposed arbitrators, or very few of them, are African Americans, and that made a lot of news, and highlight the problems in this regard. And so there's most of the major arbitral institutions have started to try to redress that, either by increase the number of diverse attorneys or arbitrators in the panels. There's also organizations such as Arbitral Women, and a recent organization that Nancy is involved in called REAL. I think it's Racial Equality for Arbitration Lawyers, which is a phenomenal organization that try to highlight these issues. So there's definitely a lot of effort in that regard, but I think the bottom line is the corporate clients have to be actively involved, because they're the one that decide, right? They're the one that tell the outside counsel what to do, who to select ultimately, because money talks, right? So I think the corporation, the client, should do a bigger part in promoting diversity in that arena, and that's the most effective way to go about it. Last but not least, actually, Professor Benton, Gary, has come up with some new proposal a few years ago that that create a lot of waste, and which I agree with him. I think he proposed that all arbitral panels should include at least one woman, or all the diverse panelists. Because otherwise it we consider as a defective panels, and that make people pay more attention to the issue and debate the issue, right? So that's the diversity aspect of it. Now let's talk briefly about the selection process. I know I have very limited time, so I try to be as concise as possible. One of the fundamental expectation of any party to a dispute is that the person deciding the dispute is independent or impartial. By independent, we mean that there's a lack of relations with a party that might influence the decision-making process. And by impartial, we talk about the absence of bias toward one of the parties. And to provide guidance to the arbitrators and counsel, the International Bar Association has come up with the guidelines on conflicts of interest, which basically a very useful guideline to suggest an arbitrator should disclose potential conflicts or simply not accept the appointment. These guidelines are guidelines, they're not binding, but they are fairly influential, fairly actually acceptable in the community. The disclosure actually is a very important aspect of this whole process, because oftentimes this is one of the reasons why a party would challenge an arbitration award. I actually just finished a case recently where I represented a state-owned company based in the Middle East that obtained a fairly significant award against a California construction company. And when we came into California to try to enforce the award, the argument raised by the California company was that the arbitrator has failed to disclose the fact that his corporate partners a few years earlier have done work for the government of this particular, of this particular country. And that was their main argument. But I don't want to get into the detail of the case, but basically it was heavily litigated and the case actually settled. But so just to highlight the importance of disclosure, let's talk about the selection of arbitrators. This is, as I said earlier, this is a very important decision in the case, and you have to spend a lot of time trying to do the research on arbitrators. Couple of factors to consider. The number one factor for me personally is, whether the arbitrator knows the counsel or the law firm involved in this case. Obviously, you don't want to appoint an arbitrator that has a long-standing relationship with the other side, for obvious reason. Conversely, you want, I think, an arbitrator that knows you, as I said earlier, or your firm, so that in terms of credibility, your credibility could be enhanced. Obviously, you also need to do research as to past cases or decisions made by this arbitrator through research online and so forth. You also want to see whether the arbitrator has subject matter expertise, particularly, for example, in cases like construction disputes, is highly technical and you want someone to have that kind of experience in the field, right? Sometimes you want to have an arbitrator that has knowledge of the legal system. For example, some case might be based on the UK law or Singapore law. You want someone who have had experience dealing with this kind of legal systems before, right? And last but not least, you want to look for arbitrator that has a manageable caseload, because if the arbitrator is very high profile and very high demand, he or she might be too busy to work on your case, right? It might take a year or two, a year or so, or several months before he or she return the arbitration award. So that is a practical consideration that you must be mindful about. So those are my general comments, overview comments regarding the selection process and the diversity issue. Happy to answer other questions that you might have. Thank you.
Great, Luan. Thanks. Nancy, do you want to jump back in and share a little bit more about some of the things you've been doing on the diversity side? It's really interesting.
Thank you, Gary. I did want to say that if we are defining diversity as nationality, then the institutions are doing an excellent job. And I'm thinking in terms of ICC. You look on the ICC courts, you have people from all over the world, over 90 people, over 90 countries and jurisdictions. You have, and then the ICC court has gender parity. You look at the ICC statistics, they publish the nationality of the parties as well as the arbitrators. SEC does that. I think ICC was one of the first institutions that published, they've been publishing for over 20 years, their statistics, and other institutions also do that. So when you look at those numbers, it's diverse, it's international, but is it diversity in terms of ethnicity? And that's where the problem is. And in all fairness, I don't think anybody was looking at that issue for a very long time, because arbitration, the modern iteration of arbitration, really exploded in the 1900s, right? This modern iteration in the mid 1900s. And then you had people that were working in government of a certain culture, a predominantly Western culture, pushing it, moving it. And they also represented the companies that were investing abroad. But now, especially now in this age that we're dealing with the pandemic, with the social upheavals, the demand for justice, especially by a number of minority groups all over the world, we are delving into the numbers because the arbitral institutions do not ask ethnicity. And if you look around the world, Brazil has over 12, so 17 different ethnicities. For example, how do we define ethnicity? I think that is an issue. So I think a lot of them took the easy way out and just looked at nationality. But I believe, like in the US, where you see a problem, there are not that many diverse people. We can just look in the US and say, who are the pool of our arbitrators? Where are the Asian Americans? Where are the Latin Americans? Where are the African Americans, especially the African Americans? And you look at their influence in the economy of the country, and you see the lack of appearance in the decision makers of those commercial disputes, there's a problem. So one of the things that I did personally was try to, with Catherine Simpson, come up with a list of African-American arbitrators, because especially after the Jay-Z case, it was clear to us, where are they? Yes, they're dealing with employment disputes, they're dealing with the commercial disputes, they're dealing with insurance dispute, but where are they in the complex commercial disputes, in the international disputes, the ones that are really, and it became, when you look at it, sort of like a closing of an economic opportunity for a group, for a large group of people in this country. So we have that list, and what we're doing at USCIB ICC is now for the people who are not seen, are not known, even though they have been practicing for years. We haven't seen them. We are starting a Getting to Know You series, allowing the members of the nominations commission that get to decide on who is nominated to the ICC court to serve as arbitrator. Now, over 70 or 80% of the cases are the parties select their arbitrators, but in 20% of the cases, the ICC court gets to do it and then reaches out to its national committees At the US, we get to do it 15 to 20 times a year. But within that number, we really are looking to make sure that we started publishing the numbers, that you're not only going to see male and female, you are also going to see ethnic minorities. And because of the age of COVID, where we don't have the opportunity to meet with one another in person, we're doing this series, virtual meetings, meet and greet, so that the next time I put a name of a minority, experienced, qualified arbitrator in front of you, you don't say, oh, I've never heard of this person. So I'll stop there.
That's really great. And I applaud you and ICC for doing this. I know, Luan, you serve on a number of AAA ICDR committees, and they make, despite the JZ case, I think they've made a really big push as well on diversity. It seems like it's a little bit of a US-centric issue. We're a lot more focused on diversity than perhaps other jurisdictions are, but it's really critical. And there are a number of questions that have come into it. We're going to come back at the end and talk about those. But before we leave this topic for now, let me just ask you all, about the debate between party appointment versus institutional appointment. Some people argue that if the institutions were appointing the arbitrators, then we would have more diverse panels. What are your thoughts on that?
I think one of the advantages of arbitration is the ability to select arbitrators compared to litigation, right? And if you take that away from the parties, I think it takes away one of the key benefits or advantages of arbitration. So that's how I see it. I mean, I think it should remain in the parties' hands, that ability to do that.
Okay, fair enough. Fair enough. Nancy, please.
No, I was just going to say, I completely agree with Luan. What needs to happen is we need more and better information about arbitrators.
Yep.
That's the problem. Their awards are private. They're not published. Hopefully that will change progressively, but we need all that access to information about different arbitrators that we get to know by going to different expensive conferences around the world. We need to make that type of information more available.
Yeah. And it's not just conferences, of course, it's everything online now as well, with concepts relating to transparency and the arbitrator intelligence movement. So there's a lot more information out there now. Victoria, you want to add something before we move on?
Yeah, just quickly wanted to add something onto what Luan and Nancy just said. We've may have heard the term vote with your feet. People can move if they don't like it, and laws in a particular jurisdiction. Well, this would be voting with your pen. Meaning if arbitration is reconstructed in such a way that the parties are being forced, for example, to be in a system where they can't select their neutrals, they just won't pick arbitration. They'll just stop writing arbitration into their contracts, and our entire industry could, suffer for a lack of participants, for lack of parties. And so we always have to remember that arbitration is voluntary and that the parties always have a choice to not pick arbitration. And so we do have to be careful about the ways in which we encourage parties to include more diverse arbitrators in their selection. That said, I think the institutions are the ones that can help move the needle, because for most arbitrators, getting the first case is the hardest. If you're a diverse arbitrator, getting case number one is the biggest hurdle you have to jump over. And I think that's where the institutions can help a lot. Okay, great. So we'll come back to this topic. But for now, let's move on and talk about information exchange and judicial assistance. So, the US is rather notorious for having intrusive discovery, and most other countries in the world look at us and say, what are they doing there? International arbitration provides a bit of a compromise on that. And Luan, we want to hear you talk a little bit about that. And as well, in terms of judicial assistance in arbitration, be it issuing subpoenas, enforcing, of course, awards and arbitration agreements. And now there's a big debate that the Supreme Court has told us it will weigh in on with respect to judicial assistance. So tell us all about that.
Sure. For U.S. lawyers who first start doing international arbitration, I think the discovery or information exchange aspect of it is the biggest shock to the U.S. lawyers, because as U.S. lawyers, I mean, we are used to having so many tools in discovery, right? Discovery is often very extensive, lengthy, and expensive. we have all these fancy tools to play with, depositions, request for admission, written interrogatories, and so forth, that you have at your disposal before you go to trial to prepare for your case. But international arbitration is completely different. There's no deposition, no interrogatories, no request for admission, very limited document production. Usually, like for example, to compare under US litigation, the standard is generally any non-privileged document that is relevant to the dispute or the claims of defense in the case, right? Pretty large. But in international arbitration, the standard is much more narrow, something to the effect of you have to make a narrow and specific request regarding, like, a lot of times, like, specific documents you have in mind, right? So it's not uncommon for arbitral tribunal to allow only a handful of documents. The bottom line is, do not count on information or documents from the other side to prepare for your case in international arbitration. Usually you have to rely on your own documents and witnesses. So that can put, like, US attorneys at disadvantage because he or she who are not used to going to the final hearing or trial without all this fancy discovery responses or deposition responses at his or her disposal. And a lot of time also the scope of discovery also depends on the legal background of the arbitrators, depending whether the arbitrators come from the common law or civil law, right? So common law, under common law jurisdiction, generally, discovery, disclosure is much more extensive, right? So very standard practice to request document or information from the other side. And again, as I say earlier, the parties are compelled to disclose documents as long as they are relevant to this case. But in a civil law jurisdiction, which, I had the fortunate, I'm actually started my legal career in Quebec. So I study civil law and I practice law in Quebec as well. So I saw the difference between the two systems. Under the civil law jurisdictions, generally speaking, the pleading party is usually required to only submit evidence it wishes to rely on. And the other side are seldom required to provide documents to the others, to a party. So then the civil law courts are very reluctant to compel evidence production, So given this difference in different legal system, the IBA, International Arbitration Association has, International Bar Association has come up with the rules and guidelines on taking of evidence in international arbitration as sort of a middle ground, to try to between the civil law and common law jurisdictions. So, for example, with respect to the document production, one of the rules is that a party may submit to the other party and the tribunal request for a narrow and specific discovery regarding category of documents. And they have to specify, what documents request, why they're relevant to the case, and what are material to the outcome of the case. And these requirements are generally aimed at preventing parties from embarking on what we call here in the US fishing expeditions, as you see here under US litigation. So there are rules like that internationally that the parties, may rely on to regarding the conduct of the information exchange in arbitration. And also the arbitral institutions also have particular rules regarding this regard. And again, I think the rules are fairly presented as a compromise between the, kind of free-for-all discovery under US litigation and the more restrictive discovery under other judicial system. Now I want to talk briefly about the judicial assistant in international arbitration. What I mean by that is, what are the role of the courts to facilitate or help international arbitration? The national courts actually play a very crucial role in that regard at every stage of the arbitration. For example, before the arbitration, the national court could, grant anti-suit injunction to enforce the arbitration agreement. Basically, if a party may try to circumvent the arbitration agreement by filing lawsuit in national courts, and the national court can issue injunction to prevent the party from from filing this lawsuit to allow the arbitration to proceed. During the arbitration proceeding, there's also, the court can also play important roles such as issuing freezing asset orders, to prevent dissipation of assets, prevent a party from destroying evidence, or request documents under the control of third parties. And I'll get to that a bit later. And after the arbitration, obviously, the national court can enforce or reject the arbitration award. Now, the Section 1782 judicial assistance, it's a very important, Section 1782 of the US Code. It's a very important tool that we have to help arbitration. It allows US federal district courts to order any party in their own district to turn over evidence to be used in proceedings before a foreign or international tribunal. That is the exact wording in the statute, a foreign or international tribunal. For example, if I'm involved in a commercial arbitration in the UK between two private parties, and I know that a party in the US, a third party, might have documents relevant to that dispute, I can go to the US District Court here in the US, in the particular district, and get an order, to order that third party to produce evidence or subject to deposition to provide evidence to help that arbitration in the UK. Now, Gary has mentioned earlier about the recent controversy involving and the recent decision by the US Supreme Court that stepped into this dispute. As I said earlier, the statutes say that it could be, this 1782 could be used to help a foreign or international tribunal. It doesn't define what exactly that means. So the controversy has been whether that would that mean international arbitration panel, like the UK private commercial arbitration that I mentioned earlier in my example, or it means something else, or it means a national court and so forth. So and the courts in the US have basically there's a circuit split between different circuits in the US regarding whether or not that would cover, this provision could cover private international arbitration in a foreign country. And the US Supreme Court actually, I think 3 days ago, has granted cert to take on this particular question. It's obviously a very important issue because if the court were to say yes, then it will give the parties in international arbitration a tremendous tool to get discovery in the US to help the arbitration. Conversely, if the answer is no, then we just lost a very useful tool that international arbitration practitioners have been using in the recent years. So that's basically what I have in mind. By the way, that case is called Servotronics v. Rolls-Royce. And as I said earlier, cert was just granted 3 days ago. Thank you.
Great. Well, thanks so much. We want to turn to the pandemic topic and at least spend 5 minutes on it, Nancy. But before we do that, I just want to follow up along something you said regarding information exchange and how US practitioners will look at it from the US perspective. There's this big pull between the idea of efficiency in arbitration and party autonomy in arbitration. And certainly, from my experience, if the parties in their agreement provide for particular, quote, US discovery, or if counsel afterwards agree that they want to do a deposition, although I think it's discouraged under all these guidelines, as an arbitrator, I would certainly allow it if that's what the parties want. Is that your experience? And Nancy, Victoria, do you have other experiences with respect to that? Again, I just think give the parties what they want. That's what this is all about.
Definitely. If the parties agree to it, then that definitely is a no-brainer, right? But oftentimes you have parties who are not from the US or clients who are not from the US international arbitration. They're like, what, deposition? No way. I'm not going to agree to that. So it has happened, but in my personal opinion, my experience, it's very rare that deposition are allowed.
Yeah. Okay, fair enough. So let's turn to the topic of the pandemic, because after all, here we are in the middle of one. Hopefully, We're almost at the end of the tunnel. There's some light out there. I sure hope so. But it has really impacted all of our lives, and as well, it's impacted the international arbitration. Nancy, please tell us about that.
Thank you, Gary. And I am gonna, look to all of you to provide your personal experiences. So in terms of the impact of the pandemic, as many of you know, international arbitration really was being done already hybrid. A lot of the document exchanges were happening virtually, via email. However, for example, the request for arbitration, the response, those were the physical document needed to be received by the institution and sent out to the parties. And that's still the case in several arbitral institutions. Also, the physical award needs to be there, physically present and sent out to the parties. But more importantly, the evidentiary hearing had, the norm was all the parties, all the arbitrators are present, and all the parties and their counsel, of course, court reporters. So there's a lot of traveling that happens. And in international arbitration, you have the parties coming from different countries, the arbitrators coming from different countries, and the counsel for the parties being based not necessarily where the client is based. So several people from all around the world taking planes, trains, whatever means necessary to make it to be physically present. The pandemic happened, causing health concerns and public restrictions on the ability to get together and what you touch and how you touch certain things. And so we all had to go virtual, and which was something that was gradually developing in the industry, but then almost overnight, the evidentiary hearing that was requiring physical presence now had to be done online, virtually, either via Zoom, WebEx, Microsoft Teams. And so some parties resisted, but for the most part, the arbitration hearings were either stayed or moved, but no one took the risk of meeting in person. So the conversation now is how to effectively present your case. And I mean, your opening, your cross-examination of the witnesses, your closing, handling of the tribunal's questions, how to do that effectively when you're doing it virtually. And for the arbitrators now, many of us have had to have these establishments where you have the headphones, 2 or 3 screens, one screen where you're seeing the witness and their counsel, another screen where you're seeing documents. So we've all sort of had to change our practices to be so much more tech savvy. And you're also looking at it with respect to the exchange of document, cybersecurity. I believe the world has definitely changed. And we are, hopefully when this pandemic ends, and it will end soon, hopefully, we are going to be at a hybrid system, because I think you will never erase from the client's mind how much they're able to save by holding these evidentiary hearings or or case management conferences virtually or online or by telephone conference, and also the climate change impact being saved by not having so many people being physically present in different locations around the world, or shipping so many pages, hundreds or thousands of pages of documents to different locations around the world. I think you're never going to erase the benefits of COVID. And you're probably going to have an international arbitration bar that is just much more savvy about all things technology. So I'd love to hear your opinion.
Victoria, Luan, you want to jump in? Are we going to be video conferencing next year, or are we traveling around the world?
I'll jump in and for a little bit. I'm going to say that we're going to be doing video conferencing more. But it's not just going to be because of the reasons I think that Nancy articulated. I think it's also going to be that all these businesses that we work for, or in my case, a university, have realized they're saving a whole lot of money not sending people around the world. And if we don't have to start sending people around the world again, why should we spend that money? So I actually think that we're going to be finding a lot of organizations that are requiring the folks who work for them to justify travel a lot more than they used to. Why do you have to go there instead of doing a video conference? Is going to be the question, I think, going forward. So anyway, that's just one thing I'd add.
Yeah, I totally agree. I mean, law firms realize that they've been saving so much money the past year on travels and related expenses, and so are the clients. And I agree that, you know, video conference is here to stay for a long time. For me personally, you know, and for those who involve international arbitration disputes, from a personal standpoint, actually, I very much enjoy. I don't miss. I used to go to Asia every 5 weeks, and seems like I was always jet lag, you know, and tired, plus away from my family and my kids. So I really enjoy this from a personal standpoint. But I agree that this is the future, and I think we'll see more and more even after pandemic is over. Clients insisting on having this proceeding be done by video conference for cost reasons. Especially we're talking about international arbitration, where we have people from all over the world, like witnesses, arbitrator, counsel, and that's a lot of expenses.
Yeah, I think you're all right. I mean, ultimately, it's all about the clients and keeping them happy, and it's just not cost efficient to travel. The only complication, of course, are, you know, time zones. And fortunately, I have some cases right now with arbitrators in London, and the cases are seated in Hong Kong and Singapore. So I am going to Hong Kong and Singapore after the pandemic is over, and I am ready for my dim sum. I'm ready for my hawker markets, but I realize that might be short-lived. Hey, we have about 10 minutes. There are a whole lot of questions that the audience has shared with us, and I want to go over those with all of you. The first one was directed to Victoria, but really you all can answer it. And that is arbitration losing its charm due to high cost, long time, and lack of transparency?
Well, since it was directed at me, I'll start, but feel free to jump in, everybody. I would say the answer is no, because of the other reasons that Gary had on his slide, which I think are really important. Privacy is crucial. When you have a court case, you don't have privacy. Enforceability. Most court judgments are not enforceable past the boundaries of the nation in which that court sits, whereas arbitration, you got 160 jurisdictions in which you can take your award. So there are benefits, I think, that arbitration has that litigation may never have. Although there is the Hague Convention on the Enforcement of Foreign Judgments, but there aren't many takers. I think they only have like 2 or 3 signatories, or I could be wrong on the number, but they're not as big, of course, as the New York Convention. So I don't think litigation will overtake arbitration anytime soon.
I represent a lot of major U.S. company doing business in Asia, especially in more developed countries or developing countries. There's no way that they would agree to have the dispute resolved before the national courts for obvious bias reasons. So I think arbitration is here to stay in international contracts, especially the larger contracts. And obviously, like Victoria said, the enforceability is such a key advantage of an arbitration.
Okay, great.
I agree, but it is important to also note that all the institutions are being responsive to the perception that arbitration has gotten cumbersome procedurally and takes a long time. So many of them, all of the ones you saw on Gary's slide, have implemented expedited procedural rules to help the arbitrations run quicker, faster, more efficiently, and more cost effectively.
And a lot of them also have come up with rules allowing for early dismissal, you know, MSJ, motion of summary judgment type procedures in recent years.
Yeah, and there's no question that there's been, at least in the US, the sort of Americanization of international arbitration, where we do, you know, add more and more discovery-like processes, and that can increase the cost a little bit. But I think ultimately it goes back to what you all said, that you want the neutrality of international arbitration. You want the international enforcement that international arbitration offers. So many, you know, U.S. corporate counsel think they can just go to a U.S. court and enforce their judgment internationally, and they can't. And so that is a big impact when they sort that out. There's another question, kind of a tougher question here. deals with competence. So that's again, the doctrine, for those of you listening, that the arbitrators, he or she, can decide his or her own jurisdiction. And the question is, does it work for arbitrators to adjudicate and resolve pathological clauses in international commercial arbitration? Or is that something that, because it's international, the national courts do? Someone want to try to tackle that one?
I'll do it. I'll start and try it. That's a very good question. Very good question. So one of the things, if you have institutional arbitration, or even the ad hoc under trial arbitration rules, the provision of the rules are deemed incorporated into the parties' agreement, right? They're part of the parties' agreement, they're part of the whole consent. And most of those rules will provide that. Especially under institutional arbitration, the issues of competence, where you have a pathological clause, the institution acts as the gatekeeper to make that initial determination according to their rules, whether the clause will fly, for example, is sufficient for the arbitration to proceed. So if the institution determines that it is, then the tribunal decides, will also have an opportunity to decide if ultimately they deemed the arbitration agreement to give them jurisdiction. But if the institution says, well, no, this pathological clause is inoperable, we can't have this proceeding before us, then the parties can go to the national courts to have a court ultimately decide that decision. Now, in the first scenario where the institution says, yes, it's good to go, and the tribunal is in place, that doesn't stop the parties from running to national courts to try to argue otherwise. But the institution, it is the institution that acts as the gatekeeper for that type of competence analysis.
Okay, great, thank you. So please, Victoria.
Yeah, I'll just be really quick. Nancy's absolutely right. And that was a very very clear answer to a very complex question. There is one other layer of complexity that can be added on, which under US law, we call this the delegation problem. And so parties actually can write into their clause that they delegate validity and enforcement of the arbitration agreement to a court. They actually can write that in. And if they were to do that, then that means that they would be taking that decision away from the arbitrator. That's not common in international arbitration, but it is possible, at least under the jurisprudence of the United States Supreme Court. But in the vast majority of cases, Nancy's absolutely right. By selecting arbitration rules, those arbitration rules include that the arbitrator is competent to decide upon the validity of the clause, which may include that the arbitrator says, I have no jurisdiction, which would also be valid.
And if we had more time, we would talk about the new restatement of US law and what it says about delegation, but we're going to leave that one for another day. Two last questions in the 3 or 4 minutes that we have left, and they're both on diversity. And the first one is, what more should be done about increasing diversity?
I'll take this one. I look at this from my experience working to increase diversity in the legal profession, generally speaking. Again, I think that much progress has been made in that regard, due in large part to the instruction or commitment from the general counsel of the large companies. Because again, they're the one that pay the bills, they're the one that lead the efforts. And so I think the same is true with respect to increasing diversity in the arbitration arena. Secondly, it takes a village, right? Not only the corporate client, but also the law firms have to do their part by empowering their diverse attorneys and give them meaningful role in international arbitration, not just a token role, but also a lead counsel status or, co-lead in arbitration, so that he or she can have, the diverse attorneys can have meaningful experience, which in turn would make them, desirable candidates for appointment as arbitrators. So I think those are the two things that I think from an institutional standpoint need to be done.
Okay, great. And then the last question that we have time for is also on diversity. I'm going to turn up the screen share and so I can see you all. And the question is, how can I get involved in the diversity effort? So who wants to tell us about that? Name some of the organizations at least that are involved and what people online can do.
Well, Luan mentioned REAL, which is the um, racial equality for arbitration lawyers. And they are now looking for people to volunteer in the committees, not only to head the committees, but to volunteer in the committees. And the board are very well-known arbitration practitioners, and as members and active participants are a lot of arbitral institutions and organizations from all over the world. So it really is, how do you want to get involved? REAL is there, a global platform, but all the arbitral institutions also have programs and projects. So how do you want to get involved? Do you want to get involved as somebody who wants to help advance your career by becoming better, more visible? The institutions, all of them, AAA, CPR, ICDR, ICDR and AAA, both the international and domestic arm, and ICC have opportunities. Do you want to be involved as a mentor? So the bar associations are also focusing on that, because Luan made a great point that this is a problem of the legal profession. We need to be more inclusive in the profession and make sure that those that we get actually become some of the decision makers later on. And so there are different possibilities, and I invite you to email me afterwards, and I will send you an email with the list directly.
That's great. That's great, Nancy. And there, in addition to REAL, there's Arbitral Women. There are a whole number of other organizations, some affiliated, some unaffiliated with the institutions, as you said, and many of the young arbitrator affiliates of all the institutions are available as well and do a lot of programming. So
that's right. And we're doing a Black, I think Chris has started a Black lawyers, Black arbitration lawyers, a group, Chris Campbell from Baker Hughes. So there are different opportunities, some more developed than others, but everyone is really looking at this issue, and I see more determination than ever to have a positive impact, to make change.
Okay.
Sustainable change.
For those of you in the US, the New York International Arbitration Center has a whole list of programs going on around the US. There are many programs on point that you can listen to. All right, well, with that, I think we are out of time. This has just been a delight for me. I thank you all so much. I really can't wait to see you all in person. I have to admit that, but thank you all for joining all of us at Santa Clara University today. And again, I look forward to seeing you all so soon. Thank you.
Thank
and
you.
now,
Thank you.
Thanks, everybody.
thank you. And Quad, Jackie, and Melina, back to all of you, and Michael.
Yes, thank you so much, Professor Benton, all of our great panelists. That was just such a great and such an enriching discussion that we just had. We want to let everyone know that we will be now taking an hour break, and then we will be returning at 5:15 p.m. and then we will begin our panel 3 and conclude with our keynote speaker. Thank you so much.
Thank you. And thank you, Gary, Luan, Victoria. Wonderful seeing all of you, and to
Thank you. Thanks,
Santa
Gary.
Clara University.
Thank
Bye.
you.
Thank you, Santa Clara.
Bye-bye.
Bye, Qua.
My AirPods were working fine all day, and just before I dialed into this, I heard a little funny noise. So I'm a little panicked that I might lose my audio, in which case I will, hopefully I can talk through my computer, but we'll see, just as a heads up.
All right, well, you sound fine from this end at the moment.
Yeah, I fear that they're going to die. I mean, they've been charging every single time I haven't been on a line, so I'm a little, we'll see. Fingers crossed.
Alrighty, it is already 5:15, so why don't we go ahead and get started for this panel. So welcome back, attendees. We will go ahead and pick up our events after finishing with panel number 2's discussion on the procedural issues in an arbitration proceeding. We will now continue with panel number 3 with a discussion on the application of arbitration in the modern age with our phenomenal speakers from the 3 sectors of IP, construction, and energy disputes. This panel will be led by our very own university's Professor David Sloss. Professor Sloss, I will hand it over to you.
All right, thank you very much. And thanks to everyone who is attending and looking forward to a really interesting discussion here. So I'm David Sloss. I'm a professor at Santa Clara University. I'm going to introduce the other speakers, and then we're going to keep this very conversational and have a sort of a conversation rather than 3 separate presentations. At least that's the idea. I do want to remind people that this session is being recorded, and if you have questions, you can use the Q&A function that you should see at the bottom of your screen, but we're going to generally hold questions until the end and reserve probably about 15 minutes at the end for Q&A. So let me go ahead and introduce our speakers, starting with Matthew Christensen. He is a senior foreign attorney with the law firm of Kim and Chong in Seoul, Korea. He works in their international arbitration and cross-border litigation practice. He also currently serves as chair of the International Construction Projects Committee for the Inter-Pacific Bar Association. For his contributions to practice of international arbitration in Korea, he has received a special commendation from the Korean Ministry of Trade, Industry, and Energy. So he is our expert in the construction law sector. Next, I'd like to introduce Mimi Lee. She is managing counsel at Chevron Global Upstream and Gas and handles international litigation management. She's part of a team that manages litigation, arbitration, pre-disputes, and investigations stemming from Chevron's international upstream operations. So she's an expert in the energy sector. And her docket includes a variety of matters, including commercial disputes, labor and employment, complex construction claims, tax, white-collar crime, personal injury, and property damage. Then last but certainly not least, we have Mr. David Tsai. He is an IP litigation partner at Pillsbury, Winthrop, Shaw, and Pittman in San Francisco, but he also co-manages the firm's Taipei office. His practice focuses on patent, trade secret, complex breach of contract, and product defect litigation for companies innovating in biotechnology, medical devices, software, and hardware. His legal experience includes defending clients in international arbitration cases, litigating disputes in the areas of copyrights and trademarks, and preparing and prosecuting US electrical engineering patent applications and more. So he is an expert in IP and will talk to us about arbitration in the IP sector. So with those introductions, I'd like to start by asking Matthew, if you can please tell us who are the key players in a typical arbitration proceeding and what are their roles?
Thank you, David, for that, Professor Sloss, for that kind introduction. Obviously, construction arbitration is a species of arbitration more generally. And so what we see in a construction arbitration will, in many cases, be very similar to what you'll see in arbitrations in other sectors. But perhaps I can approach this question by just describing what I often see in construction disputes in practice. So as Professor Sloss mentioned, much of my work involves representing Korean contractors in arbitration proceedings arising from large-scale international construction projects. These often involve engineering, procurement, and construction of power plants or similarly complex facilities in foreign countries. In these cases, the dispute is typically between the Korean contractor and the project owner or employer, which is often a state-owned entity such as a national oil company or a national power company. These are the upstream disputes. Or it could be between the Korean contractor and a major subcontractor, such as, for example, the supplier of a turbine, generator, boiler, or other major equipment. These would be sort of downstream disputes. The contracts that we see are often based on FIDIC or other standard forms of construction contracts, but bespoke contracts are also very common. The governing law is typically the law of the jurisdiction where the project is located, or of a neutral jurisdiction with which both parties are comfortable, with English law being the most common example. And I guess due to the importance of English law in the international construction industry, we have seen a highly regarded pool of construction specialized arbitrators emerge over the years in London. And it is actually quite common in practice to appoint arbitrators from this pool in complex international construction disputes, even where the governing law is not English law. So there was a comment in the previous panel about arbitrators often being pale, stale, and male, and admittedly, this can be a problem in construction arbitration. It's an area that we're working on. Just a couple of other comments. Where the presiding arbitrator is a London-based Queen's Counsel, or where the contract is governed by English law, we often co-counsel with construction specialized English barristers, though we tend to share responsibility for oral advocacy at hearings wherever possible. Another key feature of construction arbitration is the importance of experts. An arbitration brought by the contractor or employer at the end of a project will often involve a large number of different claims, many of which will require evidentiary support from expert witnesses. And the case will, of course, often be generally be supported also by fact witnesses. And these are usually employees of the client contractor or on the other side of the employer's organization who are directly involved in the project, either on site or in the home office. So just as an overview of sort of who the key players are and what their roles are, I suppose that's what I could say. And perhaps, David, I'll stop there.
Thank you very much. That was a great overview. So I'm going to turn next to Mimi Lee. And the question I'd like to ask you is, you're viewing this from in-house sort of management. So what percentage of the disputes that you work on go to arbitration versus litigation versus mediation?
Sure. Can you hear me okay? I'm having some audio problems. Good so far? Okay, great. Thanks for having me. And again, thank you for Professor Sloss for the lovely introduction. You know, one thing I wanted to add on to Matthew's great comments in terms of the key players, I would also say from my vantage point, you know, the arbitrators themselves, the party appointed, and then the neutral or the chair. I mean, that, you know, the amount of time that we spend going agonizing over, you know, the selection process and who to select and pluses and minuses and pros and cons. And then, you know, from my old days as a trial attorney, it's almost akin to trying to read what the jury is doing, how they're receiving the evidence, and, you know, where they're going with it, how they're perceiving it, that kind of thing. So it's you know, choosing the right arbitrator for a particular matter and understanding how they will work with each other on a given dispute is always a very interesting, critical aspect of figuring out who to appoint as your arbitrator. But going back to your question, so in terms of the percentage of disputes that go to litigation versus arbitration versus mediation, it really goes back to our dispute resolution provisions in our contracts with our counterparties. So typically we have a tiered approach like most, you know, companies do, where we start with, you know, we want to give folks a reasonable opportunity to give them off-ramps, so you don't necessarily have to go full on nuclear to you know, resolve a dispute. So typically there's a direct negotiations, you know, phase where you have key decision makers, you know, get together and try to see if they can resolve the dispute. If that doesn't work, then you go to mediation. And if that doesn't work, or if the parties don't want to go through mediation, then you go to full-blown arbitration or litigation. In terms of whether you would go to court for litigation or to international arbitration, that also depends on, you know, we look back at our contract as well, but then also depends to some extent on the jurisdiction. Some parts of the world, court, having things resolved in court can actually be more efficient. And, you know, we can have particular judges who have a lot of experience hearing energy disputes or construction disputes, as Matthew's referring to. And for that reason, sometimes we will choose to have our disputes decided by a court versus going to private arbitration. In other jurisdictions, you know, a lot of times we find ourselves on the other side of a disagreement, either with the national oil company or a host government, something like that, or a largely state-owned entity, and in which case we, you know, are not looking for any special treatment. We're just looking for a fair and reasonable review of the dispute and a decision on that dispute. So we really just want to try to level the playing field, in which case arbitration is sometimes the better approach, because there is in theory, a more balanced kind of neutral panel who's going to look at a dispute and try to resolve it without any kind of view towards their alliances or connections or, you know, their tendencies there. So it really kind of depends on the jurisdiction, but all of that said, we do have a fair amount of matters that go to arbitration versus litigation. In the US, I think we have more litigation than arbitration, but on our disputes outside the US, it's, I would say, the balance is a little bit more in favor of arbitration. Oh.
Sorry, I got to unmute myself. I apologize. I'm going to turn next to David Tsai. And David, before I ask you a different question, let me just see if you want to add anything to what either of the other panelists have said on the last two questions.
Yeah, thank you, Professor Sloss, and thanks for the introduction and having me today. I think Mimi and Matthew covered a lot of what I was going to answer in terms of your next question, which I anticipate is going to be the pros and cons of the three forums. One thing I want to say is that the best part of arbitration is that the parties can agree beforehand, before there's ever a dispute, because once there's a dispute, then no party's going to agree on anything. This is when parties are like agreeing on getting together and having business together and moving forward with a business agreement is a good time to come to agreement as to where a dispute might come up and how would you handle it. So an arbitration clause is helpful in that sense, because then the parties, or even any type of clause with respect to how a dispute will be resolved, is helpful because then the parties know where they're going to end up if there is a problem. And so there's no question about, oh, wow, is this person going to sue me in South Korea because it's a South Korean company that is against me, and I'm based in Germany, or I'm based in the US. So obviously the South Korean company would prefer to be in South Korea, or it's a US company and they want everything to be in New York because the company is incorporated in New York and they want a favorable jury in New York. So it's best to have that all figured out earlier. And we always recommend our clients, whether it's entering into business or even settling a business, to figure out which form they want to be in. I think that's key, because, and sometimes arbitration is helpful. And why is arbitration helpful? And I think this is going into the pros and cons of arbitration versus litigation in a court. One of the pros is that the parties often in international arbitration get to choose their arbitrators. And oftentimes it's a panel of 3. That's helpful. That way people won't think there's any bias in terms of who's judging the case. Because oftentimes people think there's a home court advantage depending on where the arbitration is situated. So you can have arbitrators from all around the world deciding these cases. And typically if it's a 3-panel judge, if it's an international arbitration, one arbitrator is selected by one party, another one selected by another party. So one could be a Chinese arbitrator if it's a Chinese company, another one could be Italian arbitrator if they're from Italy. And then they choose the chairperson, who could be from anywhere else, right? And so there hopefully will be no bias, because of the chairperson, then it should be someone that's neutral that the 2 arbitrators decided on. And then the location-wise, it really doesn't really matter. It could be somewhere that is convenient for both parties, because the arbitration should be fair because of who will be presiding over the case has been decided through a fair process. In terms of the law, though, that's applied, certainly the arbitrators need to know the law. So that is important. And so that's part of the decision-making process with respect to which arbitrator you choose. Mimi mentioned the process of getting to arbitration or litigation. Informal discussions is always the best. You don't want to go full on nuclear, and sometimes people get really emotional about cases because it can be emotional, but it's a business and people need to sit back and say, hey, what is best for the business? And so it's best to do best to try to resolve disputes through an informal process. But if you can't, I always suggest mediation. Mediation is a process where you find a mediator that both parties can agree on. It could be a retired judge, could be a retired arbitrator, or an arbitrator. And the parties can speak through this mediator. And oftentimes, if you have a good mediator, they could show both parties where their weaknesses are. And if the decision makers, the business people, not the lawyers, not the in-house lawyers, but the business people who are making the decision whether or not to pay a certain amount of money or give up something, are there, they will realize, whoa, this is a bad decision to pay lawyers to do this. We should probably settle now. But in terms of arbitration, I think I mentioned what the benefits are. And Mimi also did too earlier, because sometimes certainly you might not find the arbitrator with the right background or right expertise, and you would rather go to litigation at a certain forum, a court, that is.
Yeah, oh, sorry. Well, I was just going to say, I completely agree with, David, your earlier comment. It's best to sort that out on the front end. It's almost like, like a prenuptial, in a marriage, because it's easier to agree on this stuff when everyone's happy and collaborative and, let's sign this deal. And the last, point when you want to sort out how you're going to sort through a dispute is when you're already fighting and maybe not even talking to each other. But I will say, though, that, this is the litigator in me, or the person who's involved in reviewing dispute resolution provisions, that I will say that the transactional folks, they always leave the dispute resolution provision to the very end to negotiate. It's like, oh, we'll just talk about it at the end. Really? This will dictate your party's rights if there is a dispute or governing law. Really? You're going to look at that last? But anyway, I totally agree. And to your point about mediation, I think mediation can be such an effective tool with the right mediator, because you really want a mediator who's just going to literally beat up both sides. You want to scare both sides into rethinking, is this case really the one we want to go to the mat on? Or, they really need, the mediator's job is really to flesh out the weaknesses for both, in both rooms, because they typically put people in 2 different rooms, and they should be, if they're doing their job, they should be scaring the heck out of each side so that they do think long and hard and critically about what they're doing. But yeah, I mean, I think, but if you don't have, for example, mediation built into your dispute resolution provision before you're in a dispute, oftentimes it's a shame because the parties should go to mediation, but they don't want to show a sign of weakness by suggesting mediation. So it's actually a better approach to say, look, I don't really want to go to mediation, but it's in our agreement, so let's go there. And there's a way to kind of not necessarily hide behind it, but rely on the terms that you previously agreed to. I think, David, you made that point as well.
Matthew, did you want to jump in here also?
Yeah, I think there are a couple of points. Obviously, the question that you put to Mimi was what percentage of disputes that we work on go to arbitration versus litigation or mediation. In my case, as a foreign attorney based in Korea, I don't actually do Korean court litigation, so all of the disputes that I work on are ultimately destined for arbitration. Now, occasionally, a non-binding form of dispute resolution, such as mediation or adjudication, will be attempted along the way, but if these are unsuccessful, the dispute will go to arbitration. And I think just a comment that we should all bear in mind as to sort of the necessity of arbitration is that the choice for binding dispute resolution is typically between litigation and arbitration, but it's often not really a choice. You can imagine, for example, a situation in which you have an EPC contract between a Korean contractor and a project owner based in a Middle Eastern jurisdiction, such as Qatar or Bahrain or Kuwait. You can easily imagine that the Korean contractor would not feel very comfortable submitting disputes to the courts of Qatar or Kuwait or Bahrain. And the project owners from those jurisdictions wouldn't want to go in Korean courts either. So in practice, arbitration in those sorts of projects is really the only option. As for mediation, there is a bit of a paradox in Korea. Domestically, mediation is very popular, and Korean courts actually do quite a lot of court annexed mediation just in the ordinary course of things. But there has traditionally been quite a reluctance among Korean parties to resolve high value international disputes through mediation. And I've always thought this is probably because for mediation to be successful, the parties have to choose to enter into a settlement agreement. And the incentives for senior managers to put their necks on the line in agreeing to a settlement that can always be second guessed by their internal rivals have been, shall we say, uncertain at best. And so from the perspective of senior management, it can, in my experience, be safer just to submit the dispute to binding arbitration, focus on choosing the right arbitrators, the right counsel, as Mimi suggested. And as was said in a previous session, really the most important decision one makes in an arbitration is the choice of arbitrators. And then once you've done that, you do that properly and you let the chips fall where they may. That is, in my experience, often the senior manager's perspective on things. But nevertheless, arbitration is a very powerful, mediation is a very powerful tool for resolving disputes. It can also preserve the relationship, which is, can be really valuable, obviously. And so I think gradually we are seeing mediation gain some traction, even for international disputes, and I would expect that trend to continue into the future. So that's what I would add to that.
Thank you. All right, so I think we'll move on to the next question. And Mimi, let me come back to you with this one. Can you explain, please, for the audience, the use of staged dispute resolution clauses in international business contracts? Talk about how common are these types of clauses?
Sure, and I kind of jumped the gun a little bit. I made reference to this a little bit earlier, right. But yeah, we do typically prefer to have kind of a staged or tiered approach for the reasons we mentioned earlier. It just gives the parties multiple opportunities to try to resolve things. I mean, it's just the outside counsel, plug your ears, but it's, it's just expensive and it's time consuming if you do end up going into a full blown dispute. Sometimes it's unavoidable, but there are some instances where there is a misunderstanding, or sometimes it's lack of clarity on what a potential claim looks like, and lack of documentation to support, a claim. I mean, our philosophy is if there's a valid claim, if it's legitimate, we want to work it out. But if not, and if it's, we're not going to work it out, we'll go to the mat on something like that. But, if it's a legitimate dispute and it's just a question of trying to figure out, what the other side's position is, what documents they have, if there is a disagreement as to, what is owed, or the work that was done on a construction project, the work orders, that change orders, that kind of thing. Sure. I mean, that's a good opportunity through direct negotiations to kind of flesh that out. To David's point, park the emotion aside, because you've got project teams who live with projects for a lot. I mean, it's like they're babies, right? And they take it kind of personally if there is a dispute or someone's making some kind of allegation. They take it personally, and so those are the wrong people who should be trying to resolve the dispute. They're just too emotional about it, and so it's better sometimes to get fresh eyes looking at it and get the litigation team involved, and they can take a good scrubbing and give a good assessment as to if this is something that we need to resolve, or or resist and take to arbitration, or to mediation, litigation, or arbitration. So it's I think, I mean, and in some instances, my group, we sort of review and approve any attempts to try to revise our I don't want to say standard, but the model that we typically follow, which is the tiered approach. In some instances, and in some jurisdictions or with some counterparties, it's not going to be worth it to go to litigation or to dispute, direct negotiations and mediation. They want to just cut right to litigation or arbitration. But even then, we like to at least have one opportunity to kind of check in and see if there's a chance to resolve it before we really commit. Because some of these matters, and Matthew does construction arbitration, that can be what seems like a lifetime, right? To get into it, get the case in and wait for an award. I mean, that's a commitment. It takes a lot of resources, in-house, and our external counsel and experts. I think we've all mentioned that. It's so you really have to be, pretty sure that this is something that you want to pursue to the bitter end sometimes.
Maybe I'll just add one comment on that, which is sort of implicit in what you said. But getting into these disputes, the cost is not just dollars, but the time and energy and focus of senior management, which is, worth a lot, because they'd rather be spending time on other stuff. So anyway, David, Tsai, would you like to add to what Mimi was saying about that?
No, I think Mimi's right. And in terms of having a tiered dispute resolution clause, it could be helpful, and it might not be helpful at all, depending on the situation, but it's good to have it in there, and it should be well written. I recommend having it because I think it gives people a little breather time period. Like, it might be for those who don't understand what a stage or tiered dispute resolution clause, basically it might give you 30 days where you notify the other party of a breach or a threat of filing an arbitration complaint. So it gives the time for the parties to decide, what am I going to do? Should I be talking to them? It's supposed to be a time where you're supposed to be talking to them and trying to resolve the issues, but sometimes it doesn't work. All we're doing is sometimes our clients are so upset, they just want to send that letter so that the clock starts ticking so they could file whatever they need to. And so it's helpful, but the key also is how the arbitration clause is written so it can be enforceable in whatever jurisdiction you're in. Because sometimes people will file a lawsuit anyways, despite what the tiered dispute resolution clause says. They'll file a lawsuit with the court, even though it's an arbitration clause in there. And then the parties will have to fight over it. And sometimes the court doesn't care, and they'll just go ahead and move forward with the litigation, which isn't right because the parties did agree on arbitration. So make sure the clauses are written in a way that they could be enforceable locally.
All right, thank you. So now we're going to focus a little bit on differences between different industries. So we have people here to speak about construction, about energy, and about intellectual property. Matthew, let me come back to you and ask you to talk about construction arbitration and what's distinctive about that. Why is it different than in other sectors?
So, Professor Sloss, I would say, in some sense, none of these features are truly distinctive, but certainly there are themes that one encounters in a construction arbitration that are more prominent than in other types of arbitration, and certain sort of characteristic features. One thing that I mentioned previously is just the very important role played by experts. These construction disputes typically involve complex technical issues, engineering issues, and we simply need experts to help us understand and make sense of the parties' differences on these sorts of points. Contractor claims, I think I mentioned earlier that when you have an arbitration that's filed by one party or the other at the end of a project, you often have basically all of the claims that somehow didn't get resolved in the course of the project, just got kicked down the road, presented in the arbitration for resolution. Or sometimes it's a more discrete issue where something simply didn't work. There was a defect or a catastrophic failure or something like that, and then you're dealing with a more narrow set of issues in those sorts of cases. But this actually underscores one kind of distinctive feature of construction arbitration, which is that disputes, including arbitration disputes, are not a kind of an extraordinary event for construction companies or project employers, like they would be for businesses in most other sectors. These are regular clients, and they go through arbitration all the time. I'm sure Mimi will attest to this in the context of the disputes that her organization deals with. Just back on the engineering, so often the contractor's claims for additional time or cost, these are very common kind of categories of claims. These will typically require support from so-called delay experts. These are experts in contract scheduling, construction scheduling, as well as from quantity surveyors who will measure and calculate the additional cost incurred. These claims for additional time and cost will very often require evidentiary support from technical experts in any number of engineering disciplines. And similarly, claims brought by the project owner for defective work will typically require the involvement of experts in these or other expert engineering disciplines. And just to give you a flavor, some of the recent cases that I've worked on have involved experts in structural engineering, seismic engineering, materials science, metallurgy, process engineering, chemical engineering, petroleum and engineering, nuclear engineering, civil engineering, wastewater treatment, hydroflushing, fitness for service testing, waterproofing, just to name a few. And so you get the feeling, you definitely in a construction arbitration encounter more than your share of engineers, and it is one of the aspects of this practice that is, I think, kind of distinctive. So maybe I'll stop there.
Actually, let me just ask one follow-up question on that. Do you have a sort of a stable of experts who you go back to on a regular basis, or is it like a new search for a new expert every time you have a different case?
So there is a stable of experts for disciplines that one uses regularly. So we have our short list of preferred delay experts or quantum experts, right? Or some engineering disciplines that one encounters frequently. And there are also large consultancies in the US or in the UK and Europe that will have experts across a number of disciplines. And so it can be kind of like one-stop shopping in a sense for sort of typical disciplines. But one often does come across a need for very specific expertise. And then it can be a real challenge to find, you know, the 1 or 2 or 3 people in the world who can really address that issue and give evidence on that issue before a tribunal in English. And so that can be a challenge.
Thank you. All right, I'm going to switch the order up here a little bit. David, let me come to you next and ask you to talk about what's distinctive about intellectual property and technology disputes.
Sure. Thank you. Well, as many of you know, if it's a patent issue, it's usually before a court. It won't be in arbitration usually. For example, in the US, if it's a US patent, that will be litigated through the federal courts in the United States because that's the proper venue for those types of issues. But certainly the parties could agree if their customers are, they work with each other, and they could have an agreement prior to that where they could agree to a certain venue for arbitration. But it's very rare. Usually there's a patent case only because someone's infringing. So usually a competitor they don't like. So there's no prior agreement. So there won't be any prior arbitration clause. So usually we'll be in court, whether it's in the US or abroad. But the other type of cases that are before arbitration tend to be trade secret cases though. And those are involving employees that have agreements with their former employers, and the former employers then accuse them of taking trade secrets or company confidential information elsewhere. And in those cases, the company will sue the employee and oftentimes also the company that the employee went to, where there's suspected or alleged trade secret misappropriation. So in those instances, those could be in arbitration because the employee had arbitration clauses, and it's oftentimes employee contracts have arbitration clauses in them. So you'll see that in the IP context. But there's also the idea of, well, and this is a thing, and I could talk about it a little bit more later, but the idea of having all arbitration or all IP related issues related to a patent portfolio, where there's patents in Japan, Taiwan, China, the US, having all those different patents litigated in an arbitration, rather than having them all litigated in separate courts, having different royalty rates set, all these different damages set. So there's talk about that, especially with patent pools and standard essential patents. And so there's also that potential of using arbitration around that. So that's the IP world right now.
All right, thank you. All right, so Mimi, tell us about the energy world.
Well, you know, I would say there's a lot of common themes across the various sectors, right, when it comes to dispute resolution. But, you know, thinking about, you know, in the energy sector, it's what I guess what would potentially make us a little bit more unique in our disputes is in arbitrations would be that, you know, we are typically, if we're operating outside the US, we are necessarily partnered with a host government or a nationally owned, you know, company, and therefore it can be a delicate kind of thing, right? I mean, it's you've got relationship issues with any counterparty, any other party to an agreement, but it's even more so when you're dealing with a host government, a nationally owned, you know, company that you're dealing with, and there you are, you've got, you know, your workforce that's there in that same country, and so it can be very delicate and kind of tricky. So it's not, you really have to balance what you're trying to achieve, your objectives, and when you really want to, when you really do have to pursue a dispute, excuse me, through arbitration or elsewhere. You know, it's not straightforward. It's not, you know, one-dimensional. You know, we could be on the right side of right on a contractual disagreement, potential disagreement, but for other reasons, political reasons, commercial reasons, to manage the relationship, you find another way, or maybe you use that as part of the negotiations on some other aspect of your presence in that part of the world. So I think that is something that makes things a little bit more unique here, because it really isn't, we're not just in it for one particular project and then we're out of there. We're there and we're residents there for many, many decades. And so it's truly a long time relationship with your other contractual party. And then, I mean, your workforce, that, a lot of times it's mostly national employees in that particular country. So it's I think that part makes it kind of interesting, or particularly, unique.
One follow-up on that. So you mentioned a lot of times the counterparty is a government or a state-owned entity. How often does that bring in a bilateral investment treaty where you've got arbitration happening under a bilateral investment treaty?
Yeah, it can happen. I mean, it really depends on the issue. And I mean, talk about your nuclear options. I mean, that is pretty nuclear, and we've gone there, but it's sort of, suing your landlord, right? Over something. So you really have to think long and hard. And there's a lot of, stakeholder engagement that goes on before you go there. And sometimes you just have to go there. And, we've gone there, other IOC, international oil companies have gone there, and sometimes you just have to, you don't have any other choice. But other times, you're dealing with a nationally owned, a state-owned company, and so it's more of a, you go with your private and confidential arbitration. But even then, you've got to be careful. And going back to earlier comments we all made in terms of, well, where would the arbitration be, and would you choose that over litigation? And that is a reason why we would prefer to use arbitration outside of that jurisdiction, to just level the playing field, and just to try to avoid some bias against us and towards the nationally owned company.
All right, well, one of the really great things about this panel is we have people who are practicing in very different contexts, right? So Mr. Tsai is with a law firm in the United States. Mr. Christensen is with a law firm overseas in Korea, and Ms. Lee is in-house counsel. So we thought it'd be good to talk a little bit about the contrast between practicing in a US law firm, practicing in-house with a big company, or practicing with a law firm overseas. So David, let me ask you to start on this and talk about what do you particularly like about being in a law firm in the United States, or what you can also talk about what you don't like, either way. But how does that shape the way you deal with sort of these issues?
Well, I mean, it's wonderful to work for a larger law firm, and I work out of both the Taipei office and our San Francisco office, and that's nice to have a change of scenery here and there. I think being part of a law firm, an international law firm, is wonderful, where you can work with different clients. I mean, Chevron's been a long time client of Pillsbury's too. And you get to meet different people. But Mimi might say otherwise, that in-house people get to meet lots of people too, which I'm sure is true. But we get to work with a lot of different issues that a lot of different companies have that are very similar. So when someone calls me up as CEO or a GC, I've already seen it probably. And so it's like within 2 seconds, I could say, this is probably what you want to think about, and it could be a business decision. It might not even be a legal issue. And all I wanted to hear was, that's all I wanted to hear to help me make my decision, how to handle it. So I think as one of the benefits of being outside counsel is you get to see a lot of different things. And a lot of times it's the same exact thing that other people are dealing with, or they might not even be dealing with it and they don't know about it. And so you warn them. And so, like, for example, last year I was in Taiwan during COVID for a few months, and I was talking about something that was not even IP related. I say, oh, this company had this issue. And she goes, oh, what is this? The GC said, oh, what is this? Tell me more. I'm interested in that. And so I gave her a little bit of advice on that, and it had nothing to do with IP at all. And sure enough, this last week, it happened to them. It's like, oh my goodness, David, what you said happened. and we're ready to fix this. So, and she goes, I know you know how to deal with this. And I was like, it's not even IP relay. It's like, well, it's not me. My other colleague who's an expert in this area can handle this issue. So we could take care of it. So, but that's the wonderful part of being outside counsel. You can have things that in mind that your clients might not have in mind because they're working on a particular project or working on a particular business solution for their inside clients. That's, I think, one of the biggest differences of working in-house versus being in an outside counsel.
All right, so as a counterpoint, Mimi, what is special about working in-house, particularly as it relates to these kinds of arbitration issues that we're talking about?
Sure. You know, I would say no timesheets, but that would be a low blow to my external counsel. But I will say that I am a recovering law firm lawyer. I mean, most of my career was still spent, at a large law firm, and then I came in-house to Chevron. So I've seen both sides, and I would say, I missed parts of it, but I think when I came over to work at in-house, it's really just. I would say the most striking thing is just the multifaceted nature of the problems that we work on. I mean, we rely heavily on our outside counsel, like David and Matthew. I mean, that's the first person we call, right, when we have a problem. But internally, we're not just working the legal issues and running it up and down the chain with internal stakeholders, but it's also, like I previously mentioned, the commercial issues and working with the business partners and understanding, what their objectives are, making sure that what we're doing is consistent with what they're trying to achieve, and we're not getting ahead of them, we're not getting them sideways with whatever it is that they're trying to achieve. Because, as everyone knows, litigation, at least, the in-house group that looks after disputes, we're not a profit center. Right. And so, our company is not in the business of being in disputes. We're in the business of providing energy around the world. So, disputes kind of get in the way of that, and, it distracts, and it takes, resources away from the work that they should be doing and over to disputes. But it really is, that's interesting. So you've got commercial issues, you've got legal issues, and you've got political issues as well. So, it really is, every day is different. You start out, you think, not every single day, but you might have your week plotted out of like, these are my calls and these are the things I'm going to work on. All it takes is one phone call, one event, one letter to our chairman, and suddenly, you're just, the flurry, and you're doing everything else but everything that you had planned to do. But, that can also be really energizing and a lot of fun, because, you're still using your legal skills and all your talents and experiences that you had practicing law out there in the real world. But then, internally, you're just working with all these various stakeholders and making sure that all, key critical stakeholders have a say, or at least are aware. That's a lot of what happens in-house, is making sure that people know, the old, motto of like, just no surprises. No one wants to be ambushed with anything. And, I preach to my team, and I preach to myself that, we have multiple clients internally, and our job is to make sure that they are always protected, that no one is surprised about anything. No one wants to walk down the hallway and have someone ask a question about something that they know nothing about, good or bad news, right? That can be a very bad day for that person. But it's a lot of fun. It's a lot of fun.
Great. Matthew, let me turn to you. You're sort of have the most unusual career path in some ways. There are lots of attorneys practice with law firms in the US and practice in-house in the US. Not that many US trained attorneys who built a career basically working for a firm overseas. So tell us what's, what you like about that and what you think is distinctive about that in terms of, your practice.
Yeah, Professor Sloss, it's true. I have kind of a unique background, I suppose. For me, I was always looking to work in Korea because I had encountered Korea. I had studied Korean history at the graduate level. I had learned Korean or at least made significant strides in that direction. Direction I'm still traveling in probably for the rest of my life. But for me, it was always about just finding a way to marry my my legal career with my interest in Korea language, culture. And so I went to Korea, and I was initially actually doing a broader practice, and I sort of found my way into arbitration. And it's been a wonderful home for me ever since. Certainly, as a U.S. qualified lawyer working in a Korean law firm, the roles that I can play are limited in certain respects. I'm not qualified in Korean law. To my knowledge, no non-Korean in the contemporary era has been. And so I don't handle Korean court litigation directly, nor do I issue Korean law advice in my own name. But I've found that in practice, these are not important impediments in arbitration, because the disputes that we handle are really more about advocacy and about effective storytelling and effective argumentation. We're often finding that we're arguing Korean law to arbitrators who are not qualified in Korean law. And you can imagine why that would be the case. If one of the parties is not from Korea, even if the Korean party nominates a Korean arbitrator, the other side probably won't do so. And the institution, if asked to sort of select the presiding arbitrator, won't choose an arbitrator of the same nationality of either of the parties typically. And so you tend to find yourself in these sorts of disputes arguing Korean law or whatever the governing law is to a panel of non-specialists in that law. And so in those instances, I often find that my general familiarity with certain areas of Korean law, contracts towards the ones that we encounter frequently, allows me to play a very effective sort of bridge role in communicating those legal principles to non-specialists. And just to give you one example, at a recent hearing that I did, and this was admittedly not a construction case, but the Korean Capital Markets Act was at issue. And I presented the legal arguments on that issue and cross-examined the opposing party's legal expert in that area at the hearing. And this is a role that I frequently play and that I enjoy. So it's certainly not an obvious kind of place for many in the audience. They wouldn't necessarily imagine themselves winding up in a situation like this. But actually in arbitration, I think that it's quite common to find people who are working outside their jurisdiction of licensure. And it tends to work in practice.
Just one follow-up, though. You used the word storytelling, and I think storytelling is really important in dispute resolution. And I wonder if you could just say a little bit more about that.
Oh, how much time do we have? Look, this is all about advocacy, and one thing that people who are interested in litigation or contentious work, arbitration, will find as you learn more about advocacy is that human beings are hardwired for storytelling, and that's how we communicate. That's how we remember information. And so effective advocates have to learn how to present their cases through stories. And it often, so there's a creative aspect to this. If these were simple disputes about applying the law, they probably wouldn't wind up in this long, expensive, contentious process. But it's because the parties have different perspectives on what happened, and to sort of explain to a decision maker why your side was in the right and occupies the moral high ground and deserves relief, is often an exercise in storytelling.
All right, now we're going to change gears and look a little bit towards the future. And here I'd like to start with David Tsai and ask you to talk about what trends you anticipate over the next 10 or 20 years that are likely to have a significant impact on the nature of legal practice in this area.
So sorry, if my internet goes out, let me know, because I think something's going on with it right now. I just got a message. I think what happened with the COVID-19 pandemic really taught us something is that we can have resolution over things like this, Zoom, effectively and efficiently, and where you could see people, you could see their movements, and even for business people to talk through mediation this way as well. Sometimes it's helpful as well. So my hope is, there's more efficiency in terms of international arbitration involving technology and the ability to do things remotely and using new tools as we get them. In terms of the IP world, as I talked about earlier, I think there's going to be hopefully more use of arbitration in terms of creating international arbitration forum to resolve issues involving standard essential patents, where companies have these massive pools, or groups of companies have massive pools of patents that cover patents all around the world. Otherwise, we're going to have incongruity in terms of the results of these different courts, because a court in London might decide that a patent's worth 50 cents. Another court in Japan might say it's $1. A US court might say it's $2, and suddenly you have a $3.50 tax, I would say, on a device, and like that's not affordable, and that's impossible, right? How can you have all these different decisions saying different things and then having them all add up? So I think you'll see hopefully something like that happening in the future. And there's a lot of talk about the different intellectual property offices across the world working together to create such an international arbitration forum. And that would be really interesting for the IP world, I think. And that's looking forward in the next 10 years or so, hopefully.
Great. All right, Mimi, what do you see when you look in your crystal ball?
Well, David stole my COVID point I was going to make, so thanks a lot, David. Too bad your internet couldn't have cut out before then. No, I'm kidding. But yeah, I mean, I agree. I mean, I think we've all learned that we can do things virtually. I mean, I never would have thought you could do a mediation virtually and effectively, but there you have it. So, let alone a merits hearing. I remember when this pandemic first started and we had shelter in place, I was on a call with numerous other in-house people, and one person said, absolutely not. We've got rights to due process. I will never agree to a merits hearing. And I was saying, well, I never say never. And, we haven't tried it yet, and we don't know how long this is going to be. So I had my big "I told you so" moment a couple of months ago, I suppose. But so I think it's teaching us efficiencies, and just the wear and tear on all of us, just all the travel. I mean, pre-pandemic, I was on the road probably every 3 or 4 weeks. And, I've sat in Matthew's offices in Seoul. I've been, my team and I used to travel everywhere. And I look back and I think, boy, I think I was just a walking zombie, those years. So I feel a little bit more rested. All of that said, I mean, you can't do everything remotely. And, we have been able to do a lot seamlessly, knock on wood, remotely as we transition into our shelter in place mode, because we have traveled so much, and because we have spent so much time with our our colleagues in country and our in external counsel in these various jurisdictions, because we have those relationships. But it's tough. I mean, and to kind of, as this continues, and for the unforeseeable future, but to some extent. But we, for example, and this is in the public domain, I mean, we acquired Noble, and we have a new jurisdiction that's very new for my team in the disputes world, and we haven't had a chance yet to go out there. Normally, we would have gone out there, we would have met the team, we would have met the business people, that kind of thing. So that's been a hindrance. But putting COVID aside and the virtual nature of practices, hearings and such, I think hopefully it's not a trend over the next 10 to 20 years, and hopefully these are just anomalies. But one thing I have seen in terms of just sort of substantive episodes, I suppose, would be when it comes to purely, commercial, civil, even administrative kinds of disputes. We have seen, and again, hopefully it's not a trend, but an effort to try to criminalize a civil dispute. And so you might have a civil dispute, but then you've got a counterparty or someone who's affiliated with your counterparty who might try to go to a regulator, or a regulator or a police kind of division or a securities agency or something in some part of the world, or tax agency, to try to create some kind of leverage to pressure us into doing something or not doing something by just distracting from the actual pure legal dispute and trying to cry that there's something else actually going on here, which is, it's unfortunate. We haven't seen a lot of it, but we have seen it on occasion. So, that has made for some interesting projects, I guess I would call them. And yeah, otherwise, I don't know about other trends, but hopefully, going back to a more positive note, that we can all kind of hold on to some of the efficiencies that we've learned from this experience in COVID.
Good. Matthew, what would you like to add about what you're seeing coming down the pike over the next decade or two?
No, if my crystal ball were clear, I would not be practicing law. I'd be on a beach somewhere. But there are in construction area, and there are various sort of technological innovations that are relevant to presenting evidence that I think will continue to be an important trend going forward. That's not only in construction, it affects other areas as well. But I am quite interested in the sort of the COVID and sort of the post-pandemic future. I know it's been touched on already, but that is kind of where we are, and it is, I think, what a lot of practitioners are thinking about now. And I fully agree with what David and Mimi have said about the sort of virtual hearings being here to stay. And I would just maybe add to that one of the real benefits of arbitration, in theory, is that it's very flexible and it is very adaptable to the needs of the particular case. And it is possible to sit down at the beginning of your case and say, what procedures do we need to resolve this particular case? And what's extraneous? Do we need discovery at all? Or is that something that's just not important to our case? Is this a case where actually the best way forward is for the tribunal to appoint an expert to decide certain issues? Arbitration is, in theory, adaptable in that way, and it's one of its great pluses. However, in practice, there is a tendency to just fall back on the tried and true procedural order number one, which prepares for all eventualities. And it's a reason why arbitration often turns out to be more time consuming and more expensive than it necessarily needs to be. But I think that this experience conducting hearings through virtual means in the pandemic will give us new opportunities to manage cases more actively. I think there will still be some issues that we decide need an in-person hearing. But that might not be everything. We might decide that there are some issues that we can decide through a virtual hearing. And so I think we will see more thought given to breaking the case up in ways that make sense, rather than just leaving everything for one consolidated hearing, a year and a half down the road from the start of the case. And I think that could have some profound implications for the practice. And I miss the travel. I miss seeing colleagues throughout the world at international conferences. And so I think those won't go away, because being in arbitration is being part of a community. But I think that the virtual hearings will be an important part of our practice going forward, and there are some benefits to them.
And I may just add one thing on that point. I mean, that may actually turn out to be a real, added advantage for arbitration versus litigation, because my guess is courts are going to go back to in-person hearings, right? Courts are not going to, I don't think, adapt to the virtual world in the same way that arbitration can adapt to the virtual world. And that may present some another sort of, advantage in the plus column for arbitration going forward. All right, so now we wanted to talk a little bit about, because I know there's a lot of students in the audience, about advice for students or also young professionals, people sort of recently out of law school. For those people who want to pursue a career in international arbitration, what is the best way to think about potential career paths? And Mimi, let me start with you on this question.
Sure, that's a great question. I would say just fundamentally meet as many people as you can, network. You need to, figure out if this is something you want to do. If you, to pursue a career in international arbitration, and if you haven't gathered this already from this discussion so far, it's a lot of hours. It's a lot of hours away from your loved ones. And, if we go back to a pre-pandemic world, a lot of hours on the road. It's a lot of work, and it can sound glamorous. I think when I first joined the company, I thought, wow, I'm going to, Bangkok or whatever. And after one trip, it's like, oh my God, I've got to go back to Bangkok. So, it can be exhausting. So, you really do, as everyone will say, it helps to be, passionate, motivated, interested, highly interested in something, because otherwise it can be a grind if your heart isn't in it. But, as a practical matter, network, there are so many organizations out there. I get involved, I'm involved quite a bit with the ITA, Institute for Transnational Arbitration. I'm sure, others on this panel are as well. And they have a program called Young ITA, which I believe is still free of charge. And that's a great, they have tons of great, events that they have, and virtual events as well, because they're younger and they're smarter and they know how to put those together. But it's a great group of individuals, and they're some of them are, learning their way, some are a little bit more established, but it really is a nice pipeline into that network. And it really is that, they call it the club, right, of international arbitrators and practitioners and such. And, you need to get into the game somehow. And, as a young professional or a law student who's thinking about it, now is the time to consider it, because there's, less pressure, I suppose, to commit necessarily. But, dip your toe in the water, figure out if this is something that interests you. And, if it's your cup of tea, go for it. I mean, and then, try to work with, when you start to practice, get with people like, Matthew and David, who are actually doing this kind of work, and who will use, work with you and give you something meaningful to do, so you have firsthand experience. You don't want to sort of be just kind of tucked away in an office doing research. You want to, have an opportunity to prep a witness or take a witness, or, maybe handle part of a procedural hearing when you start out. But you really get with someone who is really doing this kind of work and get that firsthand experience if you can. Those would be some of my suggestions.
Thank you. David, let me turn to you next. What would you like to add as words of wisdom for young attorneys?
I think Mimi said it well, like network or make friends. I think that's always very important in terms of finding friends who do this, because it is a very specialized area of practice. And if anything, if you're just starting out, if you're a young law student, a young professional, or a junior attorney, learn some good litigation skills. Arbitration and litigation, in terms of practicing in a court or practicing arbitration, uses a lot of the same skills, if not the same exact skills. I mean, there's little nuances here and there. So you learn how to be a good trial lawyer, I think. So get the experiences of asking the right questions, whether it's a direct or a cross. And you might be able to do that through a pro bono experience first. You might not get to go to arbitration yet. I started my career only doing patent litigation, and by luck, or I would say it was lucky, when I was a fourth year lawyer, I got to second chair an arbitration involving an employee trade secret misappropriation. And it was this amazing experience. I got to take the cross-examination of their expert, who was a Nobel laureate, and it was so much fun. I discredited him, believe it or not, without embarrassing him. So there's like nuances, and these things I learned beforehand through just general litigation experiences. there aren't depositions or anything like that, so those won't help as much, but those do help in a way of asking questions. How do you ask the right questions and make them sound right? And so I think being the best litigator helps a lot. Learning all the litigation skills you can have, and then networking, like Mimi said, or making friends. I like to put it that way better.
Great, thank you. Matthew, you get the last word on this question.
Sounds like David was listening when the National Institute of Trial Advocacy taught about Komodo dragon approach. You want to bite and then go away and let the witness sort of die quietly. That's the most effective approach. Sounds like he did that with his Nobel laureate. But seriously, it is true, breaking into the international arbitration community can be very difficult in practice. You need to be persistent, you need to be creative, and you need to be, in my view, open to non-traditional pathways. Positions for junior associates in the international arbitration practices of firms in the US or other common law jurisdictions are in reality very limited. You might need to start out, as David suggests, as a litigation associate and try to find a way into arbitration. That's a very common pathway and a very good pathway for the reasons that he mentioned. Or what I often see nowadays young people doing is they start out as an intern or a clerk with an arbitration institution, and sometimes maybe a series of such positions, and or as a clerk for an established full-time arbitrator. And these positions can be excellent platforms for meeting international arbitration practitioners, networking, as has been mentioned already, and they can, in time, lead to full-time positions in international arbitration practices of law firms in any number of jurisdictions. And as I mentioned before, if you want to work in this area, you don't need to confine your search to US firms, because you may find that you're doing pretty much the same work in a firm in Europe or in Asia or in other parts of the world. You could also consider getting a master's degree in international arbitration or international dispute resolution from one of the leading programs, such as the Queen Mary University of London, the MIDS program at the University of Geneva, or the LLM program in arbitration at Stockholm University, just to name a few. And I would also say, just finally, foreign language skills are not a prerequisite for a successful career in international arbitration, but they can be a very valuable asset, and you should leverage them if you have them. In my own case, Korean language ability has opened many doors. And I would advise everyone to continue developing your foreign language ability, irrespective of where it currently is. You may well find that helps you professionally, and in any event, it will enrich your life immeasurably. So that's the advice I would give.
Thank you all. All right, so now we're going to get to the part where we take questions from the audience. I see I've already got 2 questions in the question and answer box, but if you have other questions, please go ahead and type in your questions and we'll get to as many of them as we can before we have to break. The first one here is really directed to Matthew Christensen. And the question is, what is the benefit, apart from personal interest, of basing yourself in Korea?
I would just say personal interest is the driving factor for me, but it isn't for some of my colleagues. The lawyer in the office next to me is from Germany, doesn't speak Korean, but he recognized that Korea is a very strong arbitration jurisdiction. We are model law based. You heard discussion of that in the previous session. And it's possible to practice arbitration at a very high level. We have major conglomerates who are active in projects throughout the world. We have large, interesting cases. It's a wonderful place to be an international arbitration lawyer, whether or not you, as in my case, have kind of previous connections to it. So that's what I would say.
Thank you. Okay, the next question I think is not directed at a particular person, but I'll put it out there and whoever wants to take a crack, please go ahead. It says, could you please provide more information about free of charge educational programs?
Well, I guess I would, again, mention the ITA, Young ITA, Institute for Transnational Arbitration. And the Young ITA program does, it is a free membership for now, so you might want to act fast before they change it. But I do know that they often offer online programs and virtual events, so that would be one. But there are many. I mean, I think a lot of I think International Bar Association, IBA, you might want to look online there. But I think particularly now in this virtual environment, there are a lot of programs out there. But maybe David and Matthew know more.
Other comments from our panelists on that question at all?
I mean, obviously, right now there are a lot of webinars being held, and I was recently in a discussion about planning for a conference, and because of the pandemic and social distancing, the number of panels has been cut down. But we were saying, well, why we should just do these other sessions as standalone webinars. And I think that's another trend that will continue. Typically, they don't cost anything to run. They don't require you to get on an airplane. And so if people will plug into arbitration institutions, the ICC, HKIC, SIC, AAA, lots of institutions throughout the world, they can get information on these sorts of events. Also, bar associations, the IBA runs a lot of events. IPBA, which I'm quite involved in, also runs a lot of events. These are free, and a good way for you, for students to kind of get clued in on some of the recent developments in the field.
And I'll just put in a plug as an active member of the American Society of International Law. They also have a bunch of good webinars that you might find helpful. All right, I have another question here. It says the previous panel brought up the importance of picking arbitrators from the construction standpoint. What are some things, this I think is for Matthew Christensen, what are some things you would take into consideration when choosing the arbitrators presiding over your case in a construction dispute?
Well, one thing that you might be surprised to hear me say is it's not always the person who knows the most about construction and engineering. If you've got a really bad case, you might well want somebody who knows nothing, a non-specialist. And so you might look outside that field. But I mean, I think the key thing is these disputes can be difficult to get your head around, just the basic subject matter. And so it is helpful to have people who have an established track record of being able to understand the issues and write enforceable awards on these kinds of disputes. And so, if you've got a strong case, you're in an arbitration, ordinarily, you are looking for somebody with that kind of experience. Now, there are lots of generalists who have done enough construction and have some of the other qualities that you're looking for, like the ability to influence their fellow tribunal members toward an award which is sensible, which is also kind of as favorable as it can reasonably be. So there are lots of considerations. It is the most important thing that one does in a case is choose the arbitrators, and a lot of time and thought goes into it for sure.
And I think we can open that to the other panelists too. And,
yeah,
get your comments.
It's interesting because sometimes you think you have the person with the right background in terms of the technology or the issues that are at hand, but that arbitrator is going to be the worst arbitrator that you have because they might know too much and they might have their own opinions that they suddenly become the expert, even though they're not supposed to be the expert in the case. So sometimes it's better just to find someone who is a generalist, who understands, who's very smart and just understands how to interpret the law appropriately for the type of case that's at hand. I had a case where we thought, Matthew talked about language skills being really important. It is really important if you want to do international arbitration where the clients might speak a different language. We picked an arbitrator that could speak Chinese and could read Chinese because some of our witnesses were going to testify in Chinese. That arbitrator voted against us. The other side's arbitrator voted for us, and the chairperson voted for us. So we won the case, but our own arbitrator voted against us. And we thought we had the perfect arbitrator. He had the technology background. He spoke Chinese. He had worked with similar Chinese companies in the past. So we thought maybe some bias, maybe not, who knows? But we thought he was perfect for the case. But nope, the other side picked this lawyer who just was really smart and just understood the law and how to calculate like the damages and all that kind of stuff. And he just went right to the facts and says, they've won. And the chairperson, who was a very well-known arbitrator out in New York City, she saw it right away too. She goes, they've won. But our own arbitrator that we hired said we lost. So you never know.
I have another question here that's directed to Mimi Lee. I'm just going to read you the question. It says, tribunals often struggle to deal with expert reports based on different facts and methodologies, potentially even addressing different issues, and as a consequence, arriving at opposite conclusions. Is this a thing you would see often, particularly in energy disputes? And what are some important tips you have when dealing with expert witnesses for your case in the energy sector?
We have seen that on occasion, and when we do, it's usually by design, right? Because you hire your expert witnesses to help make your case, and I think Matthew even talked about this as earlier as well. And it can be more of an advocacy kind of piece. It's not a pure neutral expert. There's a reason why you hire that particular expert, and so you might see your counterparty hiring an expert who might not even have experience or expertise in the area, that specific area where your dispute lies, or what the critical kind of expertise that you need on a given technical issue. Typically, it's sort of a hyper-technical issue. But that's something that you flesh out through your external counsel, and you highlight those distinctions, how they basically missed the boat versus your expert who has robustly, comprehensively addressed the actual issues in dispute. Another aspect of, in terms of managing that or mitigating that, is through the tribunal itself. Sometimes you'll have tribunals who will coordinate that themselves and sort of put the experts together and have them work on, what are the areas of disputes, where do we agree, to kind of flesh out some of that stuff. And frankly, I find that process a little bit more efficient than just going with the battle of the experts before the tribunal and merits hearing. But that's those are some ways that we've seen it play out.
All right, if neither of the other panelists have something to add on that, I do have one other question here, and I'll put this out for whoever would like to address it. It says, what do you believe is the most misunderstood aspect of arbitration? Matthew, go ahead.
No, that's a really tough question. I guess that it's fast and cheap. It's often not. At least the big international disputes that we're tending to handle. It's not, though it can be. There are ways. I think we probably haven't done as much as we could do in terms of innovating evidence taking. I've done the National Institute of Trial Advocacy program in depositions, but I've never actually done a deposition in arbitration. And I can imagine, I'm not suggesting we would do depositions necessarily, but I think we could probably think about ways to get agreement on facts through stipulations. We could probably use interrogatories more frequently. And so I think people have a general idea that arbitration is very adaptable, but I don't think we have done as much as we could to make it more efficient.
Other thoughts about that question?
No, I would agree with Matthew's comments. I mean, you know, I think that that is always comes up in the debate, which is better, litigation or arbitration. And oftentimes the comment is, oh, well, it's far more efficient, and not necessarily. And it probably depends on the kind of dispute it is. I mean, a large mega construction dispute that goes to arbitration can take years. Whereas if you know, I've seen some disputes, construction disputes decided in certain courts and certain jurisdictions, and they're highly, highly efficient. So I would agree with that. That can be kind of misleading, you know, that perception.
All right, I've got a question here for David Tsai. I'll just read it to you. It says, we are in the Silicon Valley where tech is such a huge issue. And from my understanding, a lot of the tech disputes are preferred to be handled in court litigation. But recently there's development of organizations like SVAMC that starts to handle a lot of these tech disputes in the Silicon Valley. Do you expect for this shift to occur in the future where arbitration will become more popular in tech disputes?
Yeah, I mean, it depends on if the parties can agree to like a SVAMC or any type of arbitration forum. Like I said earlier, most times there is no prior agreement between the adversarial parties in a patent case because you're suing a competitor. It could be a non-practicing entity, patent troll suing a company. The company's not going to say, oh yeah, let's go to arbitration, right? It's very unlikely, but yeah, it might be more convenient for later, like in the future, if we could have some sort of international arbitration for standard essential patents or patents in these patent pools that involve patents from across the world. I think that makes a lot of sense, but it does come up a lot in terms of employee agreements, but employee agreements won't necessarily be all about technology, and they don't anticipate that. It could be any type of employee dispute, not just a trade secret dispute. So they won't necessarily want to go SVAMC. They might want to go with more general, like a AAA or ICC or some sort of more mainstream arbitration organization or forum to work with.
Let me just ask a follow-up on that. You said that there's rarely dispute resolution clauses in a contract, but what about patent licensing? I mean, do you know, I know that there are a lot of companies in Silicon Valley that have a lot of valuable technology that they're licensing to overseas partners. Do you get you know, arbitration clauses in those contracts, and is that, you know, or are you not seeing that because it's really more of a contract dispute than an IP dispute?
That's a great question because that's something we've raised in a recent article in Law 360 about perhaps people should start putting in arbitration as their clause in terms of licensing agreements or settlement agreements, so that it goes to a forum where it can be more standardized. So there won't be these swinging type of decisions from different forums. So that certainly is a possibility, but I just don't think that we'll see as many of those unless there's some sort of change in how people want to litigate these types of issues in the patent world. I think it's just too difficult because patent owners tend to want to litigate in the courts because they'll get better outcomes there, and they think they could get, you know, the juries on their side and get these super big awards. So I think it's going to be very hard to change that culture, but perhaps we can if there's patent reform through the government.
Hmm, hmm. All right. I think, well, I got one more question here. I think we got time for one more question. The question is, how do federal courts deal with enforcement of arbitral awards in technology disputes, especially in Silicon Valley? David, you want to take that one?
Back to me. Mimi's looking confused. She's hoping her internet goes out. Yeah, I mean, how an arbitration award is enforced, it depends on the type of case it is and where it should be, right? So sometimes it could be a trade secret misappropriation case. The companies are in Santa Clara County. It could probably be enforced in Santa Clara County Court. Sometimes the arbitration clause will say where it could be enforced or how it can be enforced and which courts it could be enforced in. Having it enforced in federal court is also a possibility. Certainly, if it's a final award that is that is supposed to be enforced in federal court, yeah, you could take it anywhere. And I didn't mention this earlier. I do work with a lot of tech companies, but oftentimes our disputes aren't about the technology itself, but rather, oh, the technology didn't work. And this is how I get dragged into international arbitrations a lot too through my clients, is that there's a dispute over whether or not the technology worked because they don't want to pay. The customer doesn't want to pay. So they say, oh, it was broken. Something's wrong with it. So we might end up in arbitration, but we need to enforce that decision. And so we oftentimes then take it to the local federal court where the company is located, or the state court. Depends on the situation, and they will be enforceable.
All right, well, I think we're out of time. So, if we were in a live format, I would have the audience clapping. So let me ask everybody to clap, even though we can't hear you or see you, but I thought that the panelists did a great job, and I really appreciate your contribution here. And remember, we have a keynote speaker coming up in about 15 minutes. So Ms. Chiann Bao will be our keynote speaker starting at 7 o'clock, and I encourage people to stick around for that. But right now we're going to take a break unless Ms. Silva or Mr. Nguyen has something they want to add here.
Yeah, thank you, Professor Sloss and panel 3 for giving us such an amazing and informative session today. Thank you very much for joining us, making this event happen. And I will turn it over to Jackie to give you all some information on the MCLE credit.
Hi, everybody. That was an incredible panel. Thank you. I'm just going to echo that. I just wanted to give a quick update. Thank you to everybody behind the scenes who has been sending me in the attendance sheets and returning the certifications. I just wanted to give a quick reminder. I'll be sending that out again for our final session. If you have missed one of the forms, please feel free to email me. My email should be in the chat for MCLE questions. And then I will make sure to get those forms over to you. Make sure you have the credit that you should have for today. So thank you.
Hello. Hello. Hello, and welcome back, everybody, to this wonderful symposium. I wanted to thank the students, International Law Journal, the student organizers for setting all this up and for asking me to introduce Chiann Bao, the Vice President of the International Chamber of Commerce International Court of Arbitration. It's really my great honor to introduce her as a symposium keynote speaker. She is a world-renowned leader in the field of international arbitration with decades of experience working in Hong Kong, London, and New York. She practices exclusively as an arbitrator and mediator and is a member of arbitration chambers. Listed on the panels of major arbitration institutions, Ms. Bao has served as tribunal chair, co-arbitrator, and sole arbitrator in ad hoc and institutional arbitrations under the ICC, Untitled, SIAC, HKIAC, KCAB, CTAC, and SCIA rules. A veritable alphabet soup, but that also shows how wide-ranging the work has been that she's been engaged in. So I think we're really fortunate to have her here. She's a fellow of the Chartered Institute of Arbitrators and the CEDR accredited mediators. Now, prior to becoming an independent arbitrator and mediator, Ms. Bao worked in private practice, where she focused on complex international arbitration and litigation, acting as counsel for corporations, state-owned corporations, enterprises, and states in a wide-ranging set of disputes, corporate work, construction, IP, licensing, joint ventures, real estate, just an entire range of what a sort of a business practice and also an arbitration practice might look at. Now, she frequently speaks and writes on the topic of international arbitration. She regularly lectures and has taught at the University of Hong Kong as an adjunct professor. She was recently appointed as an honorary senior fellow of the British Institute of International and Comparative Law. In addition to serving as the vice president of the ICC Court of Arbitration, she also serves as the chair of the ICC Commission Task Force on Arbitration and ADR. Ms. Bao's keynote is entitled Looking Forward in 2021 and Beyond, Challenges and Opportunities for International Arbitration Practitioners. On behalf of Santa Clara University School of Law, the Center for Global Law and Policy, and the International Law Journal, welcome to the symposium, Ms. Bao. You have the floor.
Thank you very much, Professor Young. And I wish to start by expressing my appreciation to the students of the Santa Clara's Journal for International Law that have organized this event from beginning to end. And Professor Young, of course, and to all of you who are attending the Friday evening Pacific Standard Time event. I have to say, just as a sidebar, I am particularly grateful for student-led initiatives, as I think that they really bring to bear the exciting future that we have in all sorts of industries, but in particular, as we see and look forward to life beyond the pandemic, and the hope that we have that the future will take us to greater heights in all sorts of areas. I am honored this evening to be able to give this year's keynote for the Santa Clara Journal for International Law's conference. It seems like a lifetime ago, indeed over a year ago, that I was not far away from Santa Clara itself. In fact, I was in San Francisco spending Lunar New Year festivities with my family and heading back to Hong Kong to face the unraveling of the pandemic. As Professor Young has said, the lecture tonight's topic is looking forward in 2021 and beyond, challenges and opportunities for international arbitration practitioners. Now, had this lecture been delivered this time last year and the topic were the same, I dare say that the themes that I've chosen would not actually have been dramatically different than they are today. What is different, of course, is the fact that in a year, the world as we know it has forever changed. Therefore, how we look forward into the future can no longer be discussed without acknowledging this moment of disruption and the consequent impact of such. Now, so I've built up this topic and these themes and It will actually be quite unsurprising, I think, to you. And so it leaves me to keep you from further suspense. And really, quite simply, what I wish to share to you is that the greatest challenge and opportunity that we face going forward is that of technology. I hope that this theme will not disappoint, as I appreciate how my choice of theme is in this moment in time, as we are all dialing in by phone a bit trite, and it is even more so when speaking at an event organized by a law school sitting in the heart of innovation and technology. The question, though, is if we all accept that technology will be the driver for opportunity and change going forward, exactly how will technology impact the arbitration industry? And more importantly, what will this mean for arbitration practitioners? The short answer is to say technology is pervasive and will impact every aspect of our industry as we know it. Breaking this down, however, I hope to offer a few ideas as for you as students honing your career or as law firm partner dusting off any pre-pandemic practices, and to develop your own personal and professional path as we come out of this pandemic. I will first define the impact I expect technology will have on international arbitration, give you some color as to the kind of technology that is already being rolled out, and share with you a few thoughts on what kind of opportunities and challenges this might bring for international arbitration practitioners. And before I get to that last point, I should warn you that, in fact, I will come with some ideas, but certainly I think many of you in the audience will have even more ideas. So the concept behind this keynote today is to really